to move the public interest litigation.
What is the public interest?
Sondeskali, your lordship, it has widely been circulated. Only your lordship kindly see this portion, then your lordship will satisfy. I'm only informing your lordships.
There is a threat, but there is nothing as such.
My lord, yes, my lord. Your lord, kindly see. Then I read, your lordship. Kindly see how
you can lower down your voice and decibel.
Well, how?
Till then, you will be equally persuasive. The allegation is so and so would come and survey a home, and whoever has a wife and girl is young, night after night, they would be there till they are satisfied. Right? Alleged a woman in a video. Allegation of sexual exploitation and land grabbing. We don't find any woman making an allegation that she has been raped.
My lord, just there's a video. There's a video.
The video that has been.
I'll give that video through pen drive.
But then first you annex the video, come up with a better petition. This petition is it does not have better particulars. Come up with a better petition.
Bail in connection.
My lord, leave to file. My lord, leave to file without certified copy, my lord. My lord,
File with the certificate.
My lord. My lord, there are 3 accused. One of them was already filed up criminal appeal in this court. So the certified copy is already lying in front of this court, my lord. My lord,
against appeal.
Yes, my lord. It's an appeal, my lord, against the order of the lower court.
Which order?
My lord. Now the co-accused in criminal appeal DB number 110 of 2022 filed a criminal appeal. He is a co-accused in this in the matter in front of the lower court. He is a co-accused. He has filed the criminal appeal. The certified copy is in front of this court. Now, my lord, my client is also filing a criminal appeal.
Against what? Are you convicted?
Yes, my lord.
Huh?
Yes, my lord.
Under what provision?
DPS Act section number 29.
And sentenced?
My lord, 12 years in prison and 1 lakh fine.
12 years in prison. You haven't filed you don't have a certified copy. So how many years you were in jail when you decided to file the appeal?
My lord, the judgment came out in February 25, 2022.
22.
Yes, my lord.
After 2 years, you've decided to file the appeal. Take it from the department, get a certified copy. My lord, department is directed to supply certified copy to the appellant.
If I may have my lord's kind leave, my lord, to mention an application, my lord, for inclusion in your an application in connection with one of the Ponzi matters, my lord, for inclusion in your lordship's list. I'm grateful, my lord.
Department director supplies certified copy.
Your lordships kind leave to mention a Group 9 appeal. It's a tender matter, my lord. The urgency is that once the work order is issued, my appeal will become infructuous. I'm praying if the matter can be urgently heard. Subject to your lordship.
Tomorrow, Friday?
Your lordship, so grateful.
Admission of appeal. It will come up in due course.
Bail in connection with appeal. May I be permitted one matter for the inclusion under the heading of bail in connection with appeal.
Milord, may I be permitted to mention, Milord, bail in connection with appeal?
Milord, bail in connection with appeal, Your Lordship.
Yes, call the list.
My lord, I appear for the petitioner, my lord.
Yes.
My lord, I have prepared a short list of date. May I hand it over to your lordships, my lord? My
Yes.
learned co-counsel is physically present before your lordships.
Yes.
Your lordships are pleased to hear on the other day that except me, all the co-accused are on bail now, my lord.
Hmm.
So, my lord, if your lordship kindly sees the first entry of my list of dates on 16 November, my lord, I have given the allegations made against all of us, my lord, against each other's name. Now, Rafiq Tawfiq Khan and Manwara Bibi are the prime accused. My lord, they have been alleged to have brought the girls. Now, the petitioner before your lordship and his wife. My lord, I am the owner of a house in the red light area. Me and my wife have been made co-accused. Ashok Roy, my lord, was also another house owner in the same area. Now, Ashok Roy, my lord, has been granted bail by this honorable court, though it was before your lordship when I had moved the earlier bail application. The only point, my lord, which was not before your lordship was that on 16th of February 2023, Manwara Bibi and Rafiq Tawfiq Khan, my lord, were granted statutory bail by the learned court below, my lord. And I am, my lord, in custody since 19 September 2023.
Yes, what is the proceeding?
Lordship, I am for the state, Lordship. A report already sent, Lordship.
Yes.
Number 9 and 11.
Rafiq and Manwara are on statutory bail.
Yes, my lord. The copy of the order, may I hand it over, my lord? It's there with my learned co-counsel, my lord.
Joyna Bibi has appeared.
Joyna Bibi, my lord, now was given an interim bail by the Honorable Supreme Court as per instructions, my lord, on 7th February 2024, my lord. The bail was allowed finally, my lord, by the Honorable Supreme Court.
February.
7th February 2024, my lord. As per instructions, my lord, I don't have the copy of the order.
Copy of the order. We'll see that. Is the order?
Sorry, my lord.
Please place that order before us.
Very well, my lord. Your lordship kindly keeps it. Tomorrow I'll get the order, my lord.
We keep it on Friday.
Your lordship.
And it council submits. Seeks adjournment to granting bail to co-accused. But Adjourned till Friday.
Grateful, my lord.
Deeply appreciated.
Yes, next matter. All the list. ठीक है. Necessary correction be made.
My lordship, the cran will be ready this Friday.
Necessary correction be made.
The cran will be ready this.
Next.
Oh, sir.
দেখো ভুল করছে এখানে. Next. Yes, your affidavit is there. These guys have published all whatever is set in court is. बस. Affidavit of the then officer in charge, Posta Police Station, Brigadier presently posted as officer in charge, Lake Police Station is placed on record. He is present in person, along with the investigating officer of the case. Stop. Copies of the affidavits are handed over to learned lawyer for the petitioner. Responses to the affidavit may be filed by Monday. Matter will appear on Wednesday. Or investigating officer so and so shall be present on that day. Presence of the officer in charge, the then officer in charge, Posta Police Station is dispensed at present.
Well, 3 years, 10 months I'm in custody. After the direction by your lordship, finally on 7th of February, charges. 13 witnesses are
13 witnesses are there, my lord. The next date is fixed on 1st of April and 2nd of April.
They have considered the materials on record. Petitioner is in custody for 3 years, 10 months. Full stop. In spite, there is inordinate delay in trial, and charge has only been framed till date. Prosecution proposes to examine 13 witnesses. There is little possibility of trial concluding in near future. Delay in the matter is not attributable to the petitioner. তারপরে ওই bail Ravi Prakash. Next.
The report may be kept in the.
Sir, these are the reports.
Your lordship adjourned the matter because my learned friends said that my lord, 2 orders of coordinate benches who similarly situated accused have been granted bail. The state said that they have assailed those orders before the Honorable Apex Court, my lord, and your lordships asked the state to file a report. My lord, the SLPs have been taken up on 2nd of February, my lord. This is the order, my lord. Both the SLPs have been discussed.
520 kg, 630 grams.
The
of
report is
gaঁজা.
placed on record. Petitioner is in custody for
5 years and 5 months.
5 years and 5 months. Bail, on the ground of delay in trial, co-accused were enlarged on bail. Their order has been affirmed by the Honorable Supreme Court. Petitioner stands on the same footing and is entitled to similar relief. Allowed.
My lord, pages 21 and 23 are the orders.
21.
Given the orders.
Next.
My lord, 9, I am for the petitioner, my lord. My lord, here, my lord, the petitioner was not identified, my lord, by, my lord, the 3 witnesses.
My lord, your
and
lordship
placed
has
those
sought for a
evidence on
report
record.
from the concerned SP.
My
my
lord,
lord.
the Caesar witnesses, my lord, could not identify me in court. And my lord, one of the members who were there in the Naka checking also did not identify me.
They were
Thereafter,
suspended, my lord. Both the my lord, police officials are presently suspended, my lord.
And then after the bail, suspension will be withdrawn. Why they have been suspended? For what purpose? For what purpose have they been suspended?
Lord, dereliction in duty, my lord.
Dereliction of duty. Where was the charge sheet? Where is the disciplinary proceeding?
Yes, it has already been started.
Hmm?
Disciplinary proceeding has already been started. They have been suspended and disciplinary proceeding is started. That is the report.
Apart from these witnesses, there are other witnesses who have identified him.
My lord, till now only 4 witnesses have been examined, my lord. Out of my lord, 4, my lord, 3 could not identify.
One has identified him.
One has identified.
after your lordship's order, my lord, another civic volunteer was examined, my lord, whose presence was not disclosed in the FIR, my lord, that he was also performing the Naka checking duty. But then, my lord, after your lordship's order, my lord, he has deposed and identified me in court.
Right.
But my lord, the Caesar witnesses, both being my lord police personnel, my lord, civic police personnel, they have not identified me. And my lord, another, the PW3, the third witness, who said he was performing a Naka checking duty, he also did not identify me.
Here we find two.
My lord, one was, my lord, in the 2 of them were in the, my lord, raiding party. Two of them were part of the raiding party, and one was a Caesar list witness, my lord.
Look, there was no raid here. my lord. These officers, the prosecution's case is that they were performing a Naka checking duty.
That
Then
itself
they
is a
intercepted
raid.
the vehicle.
That itself is a raid.
My lord, they had an information, my lord.
So these two are the public official witnesses, and a public witness also was.
Yes.
No, no. As of now, my lord, there is no public witness who has examined.
He,
No, there was a public witness, my lord.
he is saying 3 witnesses did not identify him. From your report, we find two official witnesses have been disciplinary proceeding has been started.
Against another, my lord, only Caesar witness, my lord. He was not a part of the, my lord. Subsequent to the, my lord, they were apprehended, my lord. He was just, my lord, witness to the Caesar. The third person, my lord. Yes.
The Caesar was not in presence of the accused.
Yes, my lord. My lord, these 2 persons were there when the Naka checking was going on. Subsequently, my lord, another witness is there who was not a part of the Naka checking, but at the time of.
Is he a police officer?
Yes, my lord, he is also.
Has he failed to identify?
Yes, my lord, he is also.
Then why steps were not taken against him?
PW1 ছিল না?
See, our order, paragraph 5. And submit report how prosecution witnesses who are members of the raiding party and or police witnesses to the seizure have failed to identify. What happened to that man?
এভিডেন্সটা অ্যানেক্স করেছিলেন
না,
এভিডেন্সটা Lord, you kindly see PW1, Mala. He was not there at the spot.
Right.
Subsequent to the my lord, incident, my lord, the accused persons were taken to the local place. Thereafter, my lord, the seizure was made.
So he wasn't present in the local place. The accused was not present in the local
Yes,
place.
yes, please, my lord.
So how does this man who was witness to the seizure did not see him?
So far as PW1, my lord, is concerned, my lord, similar steps should have been taken against him also.
We don't know. We asked the superintendent of police. There is no explanation. That's what we are asking. You have given a 3-page report with regard to 2 persons, who is Constable Vimal Devnath and NVF Hatasu Shingo. But what about the one who was there at the police station where the contraband and the accused was brought? He has also failed to identify. What about him? Who is that man?
So he's the same people.
So did he see the person?
So he has failed to identify also.
So why no?
I understand, but no such.
When is the next date for further trial? Who are the witnesses to this?
7th of May.
7th of May.
We get a better report on this. Report of the Superintendent of Police is placed on record. From the report, it appears the two police officers, namely Constable 424 Bimal Devnath and NBF 140089 Hatasu Kumar Shingo, who were members of the raiding party, but strangely failed to identify who were members of the police force who conducted search and seizure, but strangely failed to identify the petitioner in court, have been suspended and disciplinary proceedings have been initiated against them. Report is silent with regard to PW1.
PW1.
Name, give the name.
Namely, my lord, Hatasu Kumar Shingo.
No, that is the already action has been taken.
But the PW2 is Vimal Devnath and PW3 is Noor Alam.
Who is Noor Alam? Was he member of the raiding party?
No, yes, he was technically because he was performing the Naka checking duty along with my lord the other officers.
So
where the vehicle was intercepted.
But give the name PW3.
PW3 is Noor Alam. Noor Alam.
So constable.
No, he is a CBF member.
But with regard to role of PW3 Noor Alam, further report in this regard be filed on the adjourned date. We have gone through the material. Learned counsel for the petitioner submit. Since the prosecution witnesses have failed to identify him during trial, he may be released on bail. Learned lawyer for state content, PW4, who was also present during recovery, has identified the petition. We have considered the materials on record. With prosecution alleges petitioner was prosecution alleges petitioner was apprehended in the course of search and seizure and narcotics above commercial quantity, that is
My lord, 130 bottles of Escaf cough syrup.
130 bottles of Escaf cup syrup containing codeine phosphate was recovered. Full stop. His presence at the place of occurrence is evident from contemporaneous documents, namely Caesar memorandum, namely arrest memo and Caesar memorandum. His signatures appear on those documents. Full stop.
From a co-accused, my lord, or improvised pistol was also recovered.
We are not here for co-accused. We are here. His presence at the place is being doubted. Recovered. Full stop. Recovered. Strangely, three police personnel, namely Constable so-and-so, PWs 1, 2, and 3, failed to identify the petitioner during trial. Discipline, the conduct of the witnesses is conduct of these official witnesses, these police witnesses were most unnatural, and this court directed an inquiry into their behavior by a superior police officer. Report submitted today shows 2 of the said police personnel have been suspended and disciplinary proceedings for dereliction of duty has been initiated against them. Full stop. In the meantime, PW4, who deposed he was present at the time of search and seizure, has been examined. He has identified the petitioner. Learned counsel for petitioner strongly contends his name did not appear in the first information report. Arrested
from the spot.
No. The witness, PW4. His name did not appear in the first information report. This failure to record the presence of PW4 in the first information report cannot be the sole ground to improbabilize his version. His version corroborates documentary evidence with regard to presence of the petitioner and the spot and recovery of narcotics above commercial quantity from him. Under such circumstances and in view of statutory restrictions under 37 of NDPS Act, we are not inclined to grant bail. We request the trial court to expedite the trial and conclude the same at an early date. Further, the matter is adjourned for submission of further. 1 week.
1 week.
I'm grateful.
What is this? Oh, don't touch.
But after the petition, last meeting also no witnesses example and they got some hearing and quotation of controlled substances.
What happened between 5th to 7th?
Well, 5th to 7th, on 5th, no witness stand up. 6th, the PO was on leave, and 7th, no witness stand up.
Petitioner
The date has been fixed on 2nd April, and
petitioner is in custody for more than 2 years. He contends there is slow progress in trial and prays for bail. In view of the fact that the schedule of examination of witnesses were fixed between 5th to 7th February 2024, we adjourned in order to test the bona fides of the prosecution to conduct expeditious trial. We adjourned the hearing of the bail application. We are informed on presently we are informed on 2 out of
3 occasions, no witness stand.
During the said schedule, no witness had turned up. This exposes indifference of the prosecution to conduct trial at an to conduct trial expeditiously and conclude at an early date. Petitioner has suffered incarceration for a considerable period of time. Delay in matter is not attributable to the petitioner. Under such circumstances, we are entitled to release on bail. On the ground of next.
Lordship, I am for the petition. Lordship, last occasion I have submitted and Lordship called for a report that the chemical report was collected on 3rd of May.
Yes, what is the explanation?
Merit, I've written one.
All right. Petitioner contends that the dispatch memo from State Drug. But how the dispatch memo was dated 8/5/2023?
By the case diary, my lord, everything he has written wrong. The investigating officer.
Right, but the dispatch memo you say
But the intimation was sent to him. The dispatch memo, my lord,
we understand report was ready by 26/4
26/4, it was signed.
and it was collected on 5/5.
The dispatch was done on this, according to the case diary of 5/5, my lord, that is wrong. That is after 8/5.
Yes.
And the case diary,
Hmm.
according to the case diary, that 5/5, IO received the report.
That is wrong.
That is wrong.
He-
Because dispatch was done on 8/5.
And
So he has received that after 8/5, but very, my lord, callously, my lord, he has written that.
all was dated 8/5/2000 dispatch memo enclosing the chemical report from State Drug Laboratory. It was dated 8/5/2023, but the investigating officer received the report on 5/5/2023. Accordingly, he prays for bail. Learned lawyer for the state submits report. From the report, it appears that the report, it appears that the chemical report was signed by the Director, State Drug Control and Research Laboratory on 26/4/2023 and dispatched Vide memo dated 8/5/2023. Full stop. For reasons best known to him, the investigating officer recorded the receipt of the memo on incorrectly recorded the receipt of the memo on 5/5/2023. In view of such dereliction of duty, departmental proceeding has been initiated against him. Report is kept on record. In light of the aforesaid report, we are of the opinion there is no inconsistency with regard to the chemical examiner's report, which was prepared on 26/4/2023 and dispatched as per memo dated 8/5/2023. Entry in the case diary appears to have been incorrectly made by the investigating officer on as 5/5/2023.
The constable who collected the chemical report, his statement is that 3rd of May he went to Kolkata, 4th of May he collected. Now, subject to correction, Lordship, yes.
He can. Exactly. There the constable's statement is not incorrect because the signature has already been done on 26/4.
Lordship, it was dated 8. So it was.
Sir, the memo is dated 8.
No, memo as well as the report. Both
The
are dated 8.
report was signed on 26/4/2023.
Lordship, kindly see the report also. That was also dated 8/5/23.
It's a dispatch date, my lord. Report date is at the bottom. Now, my lord,
Show us.
the dispatch date is in the top. The report dated is in the.
Lordship, that is forwarding. Kindly see the next page, the report.
That is also at the top dated 8/5.
দাঁড়াও দাঁড়াও
Show us the document that the report is signed on 26/4.
But this is signed on 26/4.
That is a letter, but
Forwarding.
the date
Reportটা
of the report is 8/5.
chemical examination রিপোর্টটা বের করো chemical রিপোর্টটা কত পাতায় একদম ফরওয়ার্ডিং দাওটা
কি বললাম যেন?
On 26/4 to 2023, but was dated, but the memo under which it was sent was dated 8/5/2023. Full stop. Through which it was dispatched was 8/5/2023. This also does not improbabilize the fact that the police constable who collected the report physically on 4/5/2023. This also does not rule out this does not rule out the statement of the police constable who claimed that he physically collected the report on 4/5/2023 from the office of the collector, from the office of the State Drug Laboratory. In light of the aforesaid circumstances, and as the recovery of narcotics is above commercial quantity, we are not inclined to grant bail to the petitioner.
Item 12, on a last date, Lordship call for a report, more than 2 years, 8 months in custody. 8 charge sheeted witness, no witness has been examined yet.
Yes.
Charge was framed on 29/7/2022.
দাও
But although this relates to recovery of commercial quantity, but trial hasn't progressed.
Petitioner is in custody for more than 2 years. He submits there is inordinate delay in trial. He prays for bail. We have considered the materials on record and the report filed on behalf of the state with regard to status of trial. We note, in spite of protracted detention suffered by the petitioner, none of the prosecution witnesses were appeared during the schedule fixed for trial. This exposes indifference on the part of the prosecution to conduct trial with expedition under such circumstances. We are of the opinion petitioner has next.
Renewal application and Malad paying for crediting standing on same footing on another 30% granted bail by your lordship.
Granted bail by your lordship.
Petitioner is in custody for
2 years, 3 months.
2 year, 3 months. Co-accused have been enlarged on bail
Page 30.
on the ground of delay in trial. He is entitled to similar relief. Accordingly, he is released on bail. Allowed. 13. Page 13. Next.
Lordship, nothing recovered from the possession of the petitioner. Custody for 76 days. Co-accused has been granted bail. From him also nothing was recovered.
Was arrested from the spot. Thereafter, Bapi Sarkar was arrested, who named Rana Das and Sujoy Das. Rana Das has been enlarged on bail, my lord. And here, Sujoy Das is
Same footing.
same footing.
Petitioner is in custody for 76 days. No narcotics was recovered from his possession. Co-accused Rana Das, similarly circumstanced with the petitioner, has also been released on bail. Petitioner is entitled to similar relief. Allowed. Next.
Petitioner is the owner of the alleged. The last order of this month. This is my renewal application. I am in custody for 6 months. 9,007.
We have considered the materials on record. Petitioner is the owner of the vehicle which was used to transport narcotics. His bail prayer was rejected on merits in October 2023. There is hardly any change in circumstance since then. Hence, we are not inclined to grant bail at this stage. What is the stage of trial?
It was fixed on 26 February. For doing charge.
Acha, well, no change in circumstance. Thereafter, date has been fixed for recording evidence in on 26th of February.
This month. 26 February.
Framing of charge.
Yes.
Or evidence.
Framing of charge.
Framing. Thereafter, date has been fixed for consideration of charge on 26th of February. Hence, we are not inclined to grant bail at this stage. Trial court is requested to consider the issue of framing of charge on the next date, and if it is unable to do so, positively within a month thereof, and in the event charge is framed, to take proceeding to its logic. Next.
And for the petition. And this is my renewal application. Now I am in custody for 2 years, 1 month, 6 days.
250 kg of gaja was recovered. Last rejected on in the month of July. Thereafter, date has been fixed on in the 25th, 26th, 27th of the March.
30 witnesses are there. Till date, no witnesses.
It's gone where PO was only.
Petitioner is in custody for more than 2 years. He submits there is delay in trial. He prays for bail. Learned lawyer for the state. He renews his bail prayer. Learned lawyer for the state submit. Date has been fixed for recording evidence. We have considered the materials on record. Full stop. Bail prayer of the petitioner was rejected on merits earlier in view of restrictions under 37 of NDPS Act. Thereafter, there is no progress in trial, and petitioner has suffered incarceration for more than 2 years. Under such circumstances, petitioner is not responsible for the delay in trial. Under such circumstances, petitioner has made out a case for bail on the ground of Ravi Prakash. Next.
My lord, I am appearing on behalf of.
My lord, I am renewing my prayer for bail. I am in custody for 5 months. It has gone down wrongly that I was found in possession of the contract.
My lord, lastly, this application was rejected on October.
Yes. There, my lord, the order at page 17, your lordship sees that it was gone on alleged recovery was made from the petition. No. My lord, I was in custody since March. The offense took place on 21st of May.
You were the owner of the vehicle which was.
Yes, only one thing. Much prior to the offense, I was already in custody. There is nothing to show that those persons who are in the vehicle, I had any communication, any transaction.
Petitioner is in bail for more than 6 months.
5 months.
He submits. He was not involved in transporting narcotics as he was in custody.
My lord, one
At
secret
the
chamber
material of trial, learned lawyer for the he renews his bail prayer. Learned lawyer for the state opposes the bail prayer. He contends petitioner is the owner of the vehicle. Narcotics have a commercial quantity, that is.
6,000 bottles of fentanyl from 2 trucks. One belonged to my
6,000 bottles of fentanyl. Owner of the vehicle. Opposite, he contained 6,000 bottles of phencyl syrup containing codeine phosphate was recovered from 2 vehicles. Contraband was secreted in was hidden in the secret chambers of the said vehicles. Petitioner is the owner of one of the vehicles. He is involved in similar cases. We have considered the materials on record. Petitioner has criminal antecedents. He was arrested in a case involving narcotics. He is the owner of one of the trucks which was used to carry narcotics. Contraband was being carried in a secret chamber, which shows the surreptitious, which shows the intention, which shows the surreptitious manner of transportation. Full stop. Under bail prayer of petitioner was rejected earlier on merits. Under such circumstances and in view of statutory restrictions and 37, we are not inclined. Next.
My lord, I am for the petitioner, my lord.
Time for the state.
My lord, allegation under section 21C 29 of the NDPS Act, lordship. Lordship, I am in custody from 21st December 2021. That is 2 years, more than two years.
It was rejected on
And
9th of August 2023.
Lordship, all I have annexed the certified photocopy of the certified copy of the orders, lordship. Several dates has been gone by, but no witness has come, lordship. And
Please give a report.
My lord, the next date, my lord, is
You gave a report.
my lord.
Why there is delay?
On one schedule, my lord, the witnesses did not appear.
2 schedules, lordship.
My lord, lordship kindly sees.
You are annexing a bail rejection of 2021.
Lordship 8 2023, lordship, that is
All right. There's a January rejection.
that is on.
When charge was framed?
Yeah, my charge has been framed, my lord, on 4th of January 2023.
4th of January 2023.
Yes.
Let us see thereafter what you have done.
My 24th of July, my lord, was the first schedule. Thereafter, she approached this honorable court. It was rejected in August. Thereafter, my lord, another schedule was fixed in November. On that schedule, my lord, the witnesses did not appear. The next schedule is fixed on 22nd of February.
Lordship,
22nd.
first schedule was
23rd,
24th, 25th, 27th of July, lordship. 27th July. On those days, lordship, no
witness
come, and then next.
But that is what I said.
Correct. Nobody disputes. Nobody disputes.
Next 25.
That shows that you have failed 2 schedules, not examined any witness. Then petitioner is in custody for
2 years, 1 month.
2 years.
2 years and 2 years and 1 month. He contains there is delay in trial, and he contains there is delay in trial and prays for bail. Then a lawyer for the state submit. Bail prayer of the petitioner was rejected in 9th
of August.
9th of August 2023. He did not find favor. He approached the Honorable Apex Court, but subsequently withdrew his prayer. Full stop. We have date has been fixed for recording evidence in February.
On 22nd of February, 23rd of February, and 26th of February.
In February, on and from 22nd February 2024. We have considered the materials on record. It is alleged to large volume of phencyl syrup,
but 2,500 bottles
was recovered from the petitioner. Under such circumstances, bail prayer was rejected on merits in August 2023. Even before the Honorable Apex Court, even the Honorable Apex Court did not consider the petitioner's bail prayer favorably. Full stop. However,
it was withdrawn, lordship.
However, now, presently petitioner prays for bail on the ground of delay in trial. He is in custody for more than 2 years. Though two schedules were fixed, one in July 2023 and another in November 2023, for reasons best known to the prosecution, no witnesses were produced. Full stop. Petitioner has suffered incarceration for more than 2 years. Prosecution proposes to examine
9 witnesses.
9 witnesses in all. There is little possibility of trial concluding in near future. Under such circumstances, petitioner has made out a case. Bail on delay.
Grateful, Lordship.
Next.
I'm for the petitioner.
I am for the statement.
Excellent.
29 will
Excellent,
also
excellent.
arising out of phone.
Yes. My lord,
19 and 29.
29.
Who is for 29?
I am for the
Okay.
praying for parity page 6, my lord.
Lordship has been pleased to grant bail on the delay of trial
All right.
after granting of bail
One
on
more.
page
One. How long you are in custody?
More than 2 years and 6 months.
Petitioner is in custody for more than 2 years, 6 months. Sure.
My lord, same date, all 4 are
All
arrested.
right. Petitioner is in custody for more than. Now you will be 2 years, definitely 2 years, 7 months.
we have 6 months, 18.
Petitioner is in custody for more than 2 years, 6 months. He contends there is delay in trial. On such score, co-accused has been enlarged on bail. Petitioner is entitled to similar relief. Allowed. Same order in 29.
I'm deeply aware.
Until unless you do that exercise, you want to case management, you know. Yes, Mr. Bar Counsel.
Out of 11
petitioners,
witnesses.
Your Lordship.
Let.
Your Lordship, both the petitioners are in custody since 2 years, 5 months. Your Lordship, the Honorable High Court was pleased to pass an order in the same matter. The two co-accused are in bail.
Where is the order?
Page number 7, Your Lordship.
Page number 9 is Lordship. Yes, yes.
2 years, 5 months.
My lord, next date for examination 19 and 20, rest of the
2 years, 5 months. There is inordinate delay in trial. Co-accused have been enlarged on bail on similar under similar circumstances. Petitioner is ended. Hence, bail prayer of the petitioner is allowed. Allowed. जल्दी तो नहीं होगा you suddenly will find that there are 200.
May it please your Lordship. Lordship, it has been rejected.
দুটো থেকে মনে হয় এখনো হয়নি আর খবর বাড়ান
Earlier,
they will decide.
rejected several times, 2 years, 4 months. He went up to Supreme Court, page 24-25. Supreme Court gave 6 months time to complete the trial, else to renew the prayer. That was on 13th of April 2023. Till date, not a single witness has been examined. First charge.
Where is your order sheet?
Yes, last page.
Last page is only one order.
Yes.
Since the Supreme Court rejection, what happened? That has to be annexed, madam.
Yes, Lordship, that is, I have annexed. Lordship will see. Previous.
Only one. Yes, Sundar Rai, give report. Petitioner contends he is in custody for more than
2 years, 4 months.
2 years, 4 months. the Honorable Apex Court, while turning down the prayer for bail, had given liberty to the petitioner to renew the prayer after 6 months,
That was on 13th April 2000.
provided the trial is not completed within within the said period. Full stop. It is contended no witnesses have been examined since then. Learned lawyer for state shall submit status of the proceeding and reason for delay on the adjourned date. Matter will appear 1 week hence.
Highly obliged.
My lord, renewal of prayer after 10 months. I am in custody about 2 years, 3 months, my lord. 70 bottles of penicillins were recovered from my body.
What is the status of the proceeding? Where is your order?
11 witness has been cited, my lord. Out of
What?
11, 4 has been examined. My
We
lord.
want the order sheet.
Give me some time, my lord.
1 week. File the affidavit, supplementary affidavit enclosing the order sheet. Be placed on record. State shall also submit report with regard to status of proceeding and reason for delay. Next.
My lord, 2 years, 6 months. I mean,
Order sheet, madam, we will not enter.
Okay, this is
the-
File it with all the order sheet.
comments.
One order sheet will not do.
Lord,
It has been fixed on. That is as per the memo.
How long you are in custody?
2 years, 6 months.
No witness examined. 2 witnesses has been examined. 2 to 4 to 6, 8 have been examined. Now, how many witnesses left? Find out. Petitioner is in custody for more than 2 years. He prays for bail on the ground of delay. He is directed to submit supplementary affidavit enclosing the order sheet in support of order sheet of the trial court in support of his plea. Report is placed on record. A report on behalf of the state. Report is placed on record by state. Report is silent with regard to the number of witnesses. Report shows 8 witnesses have already been examined, but is silent with regard to the number of witnesses.
Next date fixed on
The number of witnesses who are yet to be examined. A more elaborate report be filed on the adjourned date. Adjourned, what, 1 week or 2 weeks? 1 week. Next. Gupta.
My lord, for the petitioner reading this prayer for bail, my lord. Petitioner custody more than 900 days. Out of 9 witnesses, only 2 examined, my lord. I have already entered the entire order sheet.
We don't understand 900 days, you know. We understand years.
Oh, my lord, 2 years, 5 months, 17 days.
Yes, where is your order sheet?
I already entered order.
Out of 9 witnesses, 2 has already been examined. This is the 4th application. 11th of March 2024 and 12th of March 2024 are the next date for evidence.
De facto complainant already failed to identify the.
Which de facto complainant failed to identify? Who is this de facto complainant?
Abhishek Talukdar, complainant.
He is a police officer. All right. Start an inquiry against him. Every police officer who fails to identify in dock must be suspended, either dismissed from service or compulsorily retired. There is two possibilities that he has forgotten. So his recollective faculty is not strong enough to keep him in the police force. Compulsory retirement. Second, he is dishonest. Intentionally, he is not recognizing. Dismissed from service. These are the two options when a police officer who was present at the time of search and seizure is unable to identify an accused. Right? Send this message to all the superintendent of police. And because of that, he will not get paid. This practice, we will stamp it at the bud. We know of this practice. Petitioner is in custody for more than 2 years. He submits there is delay in trial. He prays for bail. Learned lawyer for the, he also contains one of the, he also contains PW1, who is a member of the search and seizure team. Raiding party failed to identify the witness. Full stop. Superintendent of Police Malda shall make inquiry into the role of PW1, who, for reasons best known, who, though a member of the raiding party, strangely failed to identify the witness. This can either be due to poor recollective faculty, which renders him unfit, or for ulterior and dishonest motives. Full stop. Report by the superintendent of police shall submit report on the adjourned date. Matter will appear 2 weeks hence.
But 25, I am for the petitioner. Petitioner is in custody for 2 years and 25 days. That is around 2 years, 1 month. Now, my lord, 5 witnesses had been examined from the date of framing of charge. That was on, my lord, 19/1/2023.
That is good
But
enough.
on
Petitioner is
many
in
occasions,
custody
6
for
to 7
2 years,
occasions,
1
witness
month.
did not turn up.
He prays for delay. He prays there is delay in. He prays for bail on the ground of delay in trial. Learned lawyer for the state contends trial has considerably progressed and 5 witnesses have been examined. We have considered the
He's having antecedent. 6
Uh,
cases out of
petitioner
which
has criminal antecedents. We have considered the materials on record. Statements of witnesses and contemporaneous document show recovery of 2.2 kgs of codeine from the petitioner. Full stop. How many witnesses are there?
Lord, charge sheet shows 9, but Lord, over phone I have been told Lord 7. Lord, I stick to 9 because no written.
Full stop. 5 witnesses have already been examined and we are assured that trial shall be concluded in the near future. Under such circumstances and in view of statutory restrictions under 37 of NDPSL, we are not inclined to grant bail to the petitioner on the score of on merits or on the ground of delay. Trial court is requested to conduct the trial. When is the next date?
2nd of March and 4th.
Conduct the trial with utmost expedition and conclude the same at an early date, preferably within 8 months from the next date fixed for recording evidence without granting unnecessary adjournments. Parties shall cooperate with the trial court and communicate this order. Next.
My lord, 2 years, 7 months, 5 days I am in custody. Kindly come to the certified copy, my lord. The other orders are there, my lord. From the certified copy, my lord, first order, 29th August 2023. No witness was present. Then, my lord, the second one, no witness is present. Third one, PW8 cross-examine.
PW8?
9 witnesses, my lord, out of 13, my lord. And my lord, kindly see.
We will examine only 2 IO and expertise left.
6 months.
My lord, just
6 months. Petitioner is in custody for 2 years, 5 months.
2 years, 7 months more.
2 years, 7 months. He submits there is inordinate delay in trial. He prays for bail. Learned lawyer for the state contends most of the prosecution witnesses have been examined. Only IO and the chemical examiner is to be examined.
4 witness left, my lord.
Are you conducting the prosecution?
No, my lord. They are five.
We are telling you. He is telling you that.
Very well.
My report says.
Yet to be examined. We have considered the materials on record. Materials or allegations involve
221 kg of ganja.
221 kgs of gaja was recovered from 3 cars. Petitioners were arrested from the said vehicles while transporting narcotics. Trial has substantially progressed and 5 witnesses have been examined. 9 witnesses. We are assured by the prosecution only 2 more witnesses, that is IO and chemical examiner, would be examined. In view of the aforesaid state of affairs, we are of the opinion no case for bail either on merits or on the ground of delay is made out. We request the trial court to conduct the trial with expedition and conclude the same at an early date, preferably 6 months from the next date fixed for recording evidence. April to 6.
The report may be kept with the.
Next.
Yes, Lordship, my application, Lordship. Lordship, recovered Yaba tablet.
Yaba tablet.
Yes, Lordship. 385 days in custody. Lastly, reject on last July, Lordship, 2000.
What is the development from July?
My lord, July, my lord had rejected. Thereafter, my lord, the charge sheet was framed, my lord. Thereafter, my lord, 2 of them were absconding, 2 other co-accusers, my lord. And now, my lord, they have got anticipatory bail. My lord, next date is fixed for 16 to 23 for warrant.
Petitioner is in custody for more than a year. He submits. There is no progress in the matter since rejection of bail by this court in July 2023. He prays for bail. Learned lawyer for the state submit. Delay was due to abscondence of co-accused. Subsequently, they have appeared and date has been fixed for consideration of charge. We have considered the materials on record. A large volume of 205 grams of methamphetamine, that is Yaba tablets, were recovered from the petitioner. His bail prayer was rejected on merits in July 2023. Case could not proceed due to non-appearance of co-accused who have subsequently appeared. Date has been fixed for consideration of charge.
Warrant, execution of warrant return,
Then-
that report, my lord. Not
So they have not appeared
They have not appeared till.
due to abscondence of co-accused who have not yet appeared before the trial court. Under such circumstances, prosecution cannot be held responsible for protraction of proceedings. Hence, we are not inclined to grant bail to petitioner either on merits or on the ground of delay. Next.
Under 2 years, 2 months in custody, out of 21 witnesses, only 6 was examined.
The charge was framed in 4th September 22.
No, 4th January 2023, charge was
After the witness action started, my lord. Only one date, my lord, witness did not appear. 5 witnesses are examined, my lord. Next date for 16th April, 17th April, and 18th April, 9 witnesses have been, my lord, summoned for giving evidence. 51 kgs, my lord, were seized from a vehicle which was driving, and he is the owner of it.
Five witnesses have been examined.
Yes, ma'am.
Six.
And how
6
many?
have been examined, my lord, and 9 witnesses would be examined, my lord, on 16, 17, and 18.
No, three.
In all, how many? You give a report. Give a timeline within which you wish to examine. Petitioner is in custody for more than 2 years. He prays for bail on the ground of delay. State shall submit report with regard to the status of the proceeding and reason for delay. Report shall also disclose a timeline within which the prosecution proposes to examine remaining witnesses. Matter will appear 1 witness.
Good. Grateful.
Abscondence of co-accused. Who have
May it please read. Lordship, I am in custody for 3 years, 2 months. Lordship, two independent witness in their examination stated that I put my signature, some blank papers in the police station. I have no knowledge. Second independent also said that he has put sign.
How many witnesses examined?
Out of 12,
Hmm.
already, my lord, 9 have been examined.
9 have been.
And no inventory was made at all. No inventory.
That you argue before trial. Petitioner is in custody for 2 years, 3 months.
3 years, 2 months.
3 years, 2 months he submits. Independent witnesses stated that they signed the seizure list at the police station. No inventory was made with regard to the alleged seizure before magistrate. Accordingly, he prays for bail and a lawyer for the state submit. 9 witnesses have already been, 9 out of 12 witnesses have already been examined. Statements of witnesses and contemporaneous document, that is seizure memorandum, show recovery of 115 packets of ganja, 115 packets containing 10 kgs of ganja each. That is 1,150 kgs of ganja from a vehicle, from a truck. Petitioner was present in the truck. Official witnesses have proved recovery from the petitioner. Independent witnesses, impact of the independent witnesses resulting from their earlier statement needs to be assessed in the light of the consistent evidence of official witnesses. Consistent evidence of official witnesses on record. Failure to comply, failure to inventorize narcotics before magistrate requires to be assessed during trial. Under such circumstances, trial has considerably progressed, and there is considerably progressed. Under such circumstances, and in view of statutory restriction 37, we are not inclined to grant bail. We request the trial court to conclude the trial within 6 months from the next date fixed for recording evidence without granting. Parties shall communicate this order. Next.
Lord, I am for the petition, my lord. The petition has been in custody for about 1 year. Your lordship will find page 31, page 8 I have given. When 178 days had been completed, still charge is not been submitted. And prayer was made by the IO before the magistrate, has had rejected the prayer. So it was, I expected that he will give the charge at the time of, will give the bail order, and all these things had not been done. And your lordship find no inventory under 52A. Your lordship find, your lordship court 3 judgments are there of division bench. Without 52A compliance, no charges cannot be.
Petitioner contends he is in custody for
1 year.
1 year. Police report had not been filed within statutory period. No inventory under section 52 capital A was conducted. Accordingly, prays for bail. Learned lawyer for state submit. Okay, yes, what do you say? Police report was filed within
time. My lord, 15/3 is the FIR date. 10th of September was the statutory period. 9th of September is the charge sheet date. Although there was an application filed,
but it was not proceeded.
Page, your lordship, page 8, your lordship.
This report was filed within statutory period.
Page 8, your lordship.
Narcotics of a commercial quantity was recovered from the petitioner. Accordingly, he opposes the bail prayer. We have considered the materials on record. 1460 pieces of yaba tablet weighing 156 grams was kept in the was recovered from the residence of the petitioner. Full stop. In view,
Page 8.
police report appears to have been filed before expiry of 180 days. Hence, under these circumstances, petitioner is under these circumstances and as statutory restrictions under and in view of statutory restrictions under 37 of NDPS Act, bail prayer of the petitioner is not entitled to bail either on merits or on the ground of delay. Issue of non-compliance of section 52A request to be assessed during trial.
178 is the charge sheet.
170, the charge sheet has not been found even under 170 days, 78 days. I have annexed it.
May I
How my friend submit this? Your lordship. Page 178 days. Page, your lordship, page 8, under 178 days, charge sheet not been filed. Prayer has been made, rejected.
So 179 day charge sheet was filed.
Still not filed.
Has been filed.
No, your lordship, my
The charge sheet is annexed with the petition.
annex maybe, but when it cannot be.
All right.
Court's order is there, your lordship.
You have seen it.
Court's order is there, 170 days, charge sheet has not been filed.
When was the charge sheet filed?
The charge sheet is dated 9/9 to 20.
You give a report.
Dated. When it was
You
filed.
get a report.
And my lord,
Followed.
one more thing. A minute.
Order of the court is there,
Yes, order of the court is of 178th day.
not filed. Still not.
Yes, so next day it can be filed.
If it is shown, my lord, that's.
If it is shown is one thing, you also know.
No, my lord.
Your client should know.
No, but
Your client doesn't know.
no, my client.
Your client is not represented by a lawyer.
No, my client is in.
We reject it.
But your lordship,
Next. Hearing trial. Next.
we will submit it.
Yes, please.
My lord, I'm praying for bail on parity. The main accused.
Standing on the same footing, my lord.
Lordship,
From
please.
his house, 36 bottles of penicillin were recovered.
Yes, lordship.
Only
The
5 months in custody. Date for charge is fixed on 18th of February, and one co-accused bail has been rejected by your lordship, who was also dealing with penicillin.
Lordship will see the order passed by your lordship. The main person who has kept it, who is dealing it, he has been. Yes, he
Store, my lord, the
he's
cough syrup.
and one has been granted by Supreme Court.
From that country. One co-accused bail has been rejected by your lordship.
Petitioner is in custody for 5 months. He submits. He is not involved in dealing in narcotics. Bail prayer of co-accused Sandeep Devnath was allowed by this court. He prays for bail on parity. We have considered the materials on record. Sanjeev Devnath was a dealer in medicine. Full stop. Fencidral syrup was recovered from his possession. Full stop. In view of the fact that the said accused was a dealer in medicine, now taking note of the fact that the said accused was a dealer in medicine, he was released on bail. Petitioner is unable to produce any license which entitles him to deal in medicinal products containing codeine phosphate. On the other hand, 500 bottles of fencidral syrup containing codeine phosphate was recovered from his residence. Full stop. 36 bottles. Full stop.
I work under Sandeep, lordship. I work under Sandeep.
Well, where is your why you work under Sandeep? From his residence. This large quantity recovered from the petitioner who does not have document to justify illicit possession. Prima facie establishes the prima facie supports the prosecution allegation that the possession of possession of the medicinal product was for non-medicinal use, attracting the provisions of the NDPS Act. Hence, we are not inclined to grant bail to the petitioner on parity.
My lord, 33, my lord, I beg to appear on behalf of the petitioner. My lord, allegation is under section 22C and 29 of NDPS Act. My lord, I am in custody for 2 years, 7 months, 4 days till date. My lord, out of total 14 witnesses, my lord, only 8 witnesses have been examined. My lord, 2 times schedule has been, my lord.
Where is all these lectures? Where is the order sheet?
My lord, may I request, my lord, the order sheet, the certified copy of the original order sheet, my lord, is with me. My lord, somehow, my lord, this has been not been had.
Supplementary affidavit enclosing the order sheet of the trial court be placed on record. State shall submit report with regard to status of proceeding and reason for the Next. Pandit. Yes, state. Do you oppose the condition?
Lordship, there was a report to be submitted by us because the report was submitted by us on the last occasion. First,
your report we have seen. The matter is kept only for waiving of that condition of entering where?
Murshidabad.
Murshidabad. All right. Report be positively filed on the adjourned date 1 week.
Next Friday. My lord is keeping it on next Tuesday.
Next.
I'm grateful.
Next.
Mongol. Lord, I'm making because Lord, I'll be in personal difficulty on Monday. My lord.
My lord, I am appearing for the petitioner. Earlier, you lordships heard this matter and this. There is a my lord dispute between the two relatives regarding boundary wall. The incident happened 300 to 34. 3 accused person, 1 accused person are on bail. 2 164 statement, 164, 3 accused persons named trust, and another eyewitness only my lord, my father. The father and son in custody. That's why your lordship speaks the matter and charge has already been paid on 2nd February. Kindly see the 164 statement of Setara Bibi. Your lordship already seen. Custody 1 year, 11 months I am in custody.
You have rejected the bail.
Earlier lyric, kindly see the 164 statement. Thereafter,
you pressed him with a bamboo on the wall, and the other.
No, my father, not me. Kindly see. That's why I intend to kindly see the Setara Bibi statement.
Statement of the daughter.
Kindly see 3. Yes. Kindly see the Setara Bibi also. You losses earlier occasion seen. That's why.
Where is any other 164 state?
Setara Bibi. Yes.
Just my lord.
আমাদের আছে বার কর earlier occasion you lordship Setara Bibiটা বার করে এটা দিয়ে দিন বার করে মেন আসালেন মতিরুর রহমান
He was not the eyewitness. He was sleeping in the
না না পুরো describe আছে পুরো describe করেছি দাঁড়া তারপরে বলেছে হচ্ছে যে এই তো হ্যাঁ তারপরে এগুলো দেখুন পুরো describe করছি এই আই উইটনেস দিস ইজ আই উইটনেস
Petitioner is in custody for more than a year.
No, 1 year, 11, near about 2 years.
1 year?
11 months.
More than 1 year and 11 months. He submits. He did not participate in the assault. He renews his bail prayer. Learned lawyer for the state draws attention of the court to the statement of one Gulabi Khatun. Full stop. Daughter of the petitioner who implicates all the accused in the
One
assault.
accused persons are on bail.
We have considered the materials on record. Gulabi Khatun Gulabi Khatun, daughter of the victim, stated petitioner and others had assaulted the deceased, assaulted the victim, full stop. But Setara Bibi, in her statement before magistrate, only implicates Motiur Rahman. In view, charge has already been framed. There is no chance of abscondence. In view of the aforesaid in view of the aforesaid contradiction in the statement of the two witnesses, and as there is no chance of abscondence, we are inclined to grant bail.
ACGM, Joymalya, ACGM, additional session judge, Joymalya. Grateful.
Right, petitioner, my lord. Last question, your lordship, please to, my lord, ask the report from the state, my lord, regarding the delay of trial, my lord. I am custody for, my lord, 7 years, 1 month, my lord. Out of 72, my lord, 6 only witness has been, my lord, examined.
How many people died? 8 people died.
And 26.
Then when are you going to finish your trial? When are you going to finish your trial? This is the quality of representation by the state of West Bengal. A junior lawyer comes and defends a case where 8 persons have died and 26 persons were hospitalized. Where is the public prosecutor? Why so much delay? And this is a report. Who are you? How many accused are there?
Only one, my lord.
Only one accused.
The trial has been conducted by the DLS lawyer, my lord.
So what have you stated in your report? Who is the investigating officer of this case?
Well, give it Monday.
You want the public prosecutor to appear in this matter. Petitioner is in custody for more than 7 years and has prayed for bail. Pursuant to direction of this court, a report is filed on behalf of the state. Full stop. Perusal of the report shows the case involves an unfortunate death. Case involves the unfortunate death of 8 persons in a huge tragedy. 26 others were also hospitalized. Full stop. But in spite of the seriousness of the offense, the report, in spite of the seriousness of the offense, the report is unclear why the trial did not proceed against the sole accused, that is the petitioner, who is in custody since 2017. Full stop. Investigating officer in charge of Bagchi police station as well as investigating officer is directed to be personally present before this court with a more detailed report for the reasons for delay. Public prosecutor is directed to appear in this matter.
On Monday, my lord.
Monday.
My lord, the petitioner, he was 23-year old, a married man. The victim was 16 years old. My lord, she left voluntarily with him to Delhi. She returned back from Delhi to the city with the wife of this petitioner. My lord, for once, she is the 164 of the victim. Now the charge is framed on the last occasion. These days were fixed for framing of charge. There are altogether 16 witnesses. But kindly, I am in custody for 1.5 years.
Last date for adjourn the matter for framing of charge. And need of evidence is reached on 24th and 25th of April. It's a victim be examined.
My lord, for once, kindly, she is the 164 of the list.
Yes, the 164.
164. My lord, kindly sees. I arranged a job for her. She was not happy with the job. She left. My wife returned with her. Now, after coming back, she says, I did not got my payment.
লাভ রিলেশনশিপ লাভ রিলেশনশিপ ছিল দুজনের মধ্যে ফেসবুকে পরিচয় হয়েছিল
জগদ্দল police station, my lord, the 160 was recorded on 16th, immediately after 4 days. Sees, my lord, ki bolben bolun. Then she says, I was not given the money.
You were putting her for sex work.
No, then, my lord, she added this.
That is her statement.
That is her statement. But this is the fact remains that, my lord, she admits that she returned home with
We
my
have
wife.
considered the materials on record. Statement of the victim recorded under 164 CRPC shows that she had been taken to Delhi for sex work. Full stop. Thereafter, in view of the aforesaid circumstance, we are of the opinion this is not a fit case to grant bail till the victim is examined. Victim has not been examined at this stage. Reject. Next.
Well, in section 4 of the POCSO, she stated she was raped by this petitioner.
Victim examination over? How long you were in custody?
I'm in custody 2 years, 4 months. No, Lordship, will see on top it is written 15 years, married, husband's name.
Now 15.
Yes.
Then how long you were in custody?
2 years, 4 months.
Evidence of the victim is placed on record. Victim is a minor. She stated that she had been forcibly ravished by the petitioner. Trial is in progress. Under such circumstances, we are not inclined to grant bail. Trial be expedited.
Obliged. আমার copy, please.
I am for the petition, my lord. My lord, offense under section 326, 307. My lord, all other accused released on bail and anticipated bail, including principal accused. My lord, all allegations against Suman Vishal.
How long is
40 days in custody.
petitioner is in custody for 40 days. Who are accused are on bail. There is no chance of abscondence. Under such circumstances, we are inclined to grant bail. Hello.
Yes, ma'am. ACJM Lalwar. ACJM Lalwar.
Next.
Item number 40, I am for the petitioner, my lord. On the last day, my lord, your lordship sought for a report whether
Yes. Identity.
If that same person's lordship to identify the person, also because absconding for 12 years, thereafter.
my lord, even the record of learned trial court, my lord, says, my lord, when it was declared proclaimed offender, my lord.
The Panchayat already identified.
What Panchayat Pradhan? The Panchayat Pradhan is saying that he is staying at Habib Manik Nagar. So he also says that he is staying at Manik Nagar.
No, bad is lost it can be
The memo awareness, what will it show?
Don't put money. No, it's there. Yeah.
That is your police officer is recording.
Even my lord.
Where is the material to show that he was earlier residing at Habib Nagar? Huh? Any recovery from him?
No, my lord.
Absconding for 12 years.
My lord.
Absconding. Co-accused statement, he was that.
All right. Petitioner contends that he is Raju Sheikh, son of Yaqub Sheikh of Manik Nagar. He has been falsely implicated as Rajak Sheikh, son of Yaqub Sheikh of Habib Nagar. Full stop. In view of the aforesaid submission, investigating officer was directed to submit report whether the petitioner is Rajak Sheikh, son of Yaqub Sheikh of Habib Nagar. Full stop. Report is submitted on behalf of the investigating agency. The report relies on statement of Panchayat Pradhan of Bhakri Gram Panchayat, who merely states that petitioner is residing at Manik Nagar. There is nothing on record apart from the records prepared by the investigating agency. There is no independent material to show that petitioner was also known as Rajak Sheikh and used to reside at Habib Nagar. Full stop. In view of the lack of independent materials with regard to the identity of the petitioner as Rajak Sheikh of Habib Nagar, we are of the opinion we hold non-appearance of the petitioner in the we hold there is doubt whether the petitioner is there is doubt with regard to the identity of the petitioner as Rezzaq Sheikh, son of Yaqub Sheikh of Habibnagar. This had created this was the reason for his non-appearance in the criminal proceeding for about a decade. Under such circumstances, we are of the opinion further detention of the petitioner is not necessary and he may be released on bail, 10,000 rupees. Next.
Please, please to call for a report with
List on 23rd. CBI shall submit report with regard to the role of the petitioner. Next.
not 42 and 43 are to be heard together.
Yes.
Yeah. But the petitioner at the relevant point of time was the district inspector of schools, Purbo Midnapur. But in a local school called Kormachak High School, a person by the name of Subhendu Hatua was appointed as assistant teacher. The subject was computer application. Initially, his appointment was probationary. He was not paid any salary until blood his appointment is approved by the district inspector of schools. Later on, blood his appointment was not approved by the district inspector of schools. Blood in this court, a writ application was moved by a lady called Soma Roy, challenging the appointment of one Jasmina Khatun in a school at Bakura. But while dealing with that application, my Lord Mr. Vishwajit Basu passed an order with regard to this Subhendu Khatua also. But the order appears at page 30. But you kindly go through the order, then I will make my submission.
Yes.
That was.
Yes. Ask the public prosecutor to appear in this one. Both the matters, Monday we are fixing, ask the public prosecutor to appear. Yes, next matter.
44 and for the petitioner, I am valid on the petitioner is a pregnant lady, Miller. Your lordships on the previous occasion wanted a report from my learned friends ascertaining the veracity of the documents I have annexed at pages 9 and 10 of my application.
Your lordship, I am for the defect of complaint.
Yes, what the issue?
More than 6 months.
So let her be on bail on this ground.
My
Your
husband
lordship,
is the principal accused, he is also in custody.
Your lordship, I am for the defect of complaint. The petitioner is the principal accused, and at the time of commission of the offense, she was already pregnant. And during the ground of the humanitarian does it apply when while she was pregnant, she committed the offense.
petitioner contends that she is in the family way. She prays for bail on humanitarian consideration. Learned lawyer for the state submit report which shows that petitioner is 6 months pregnant. Is pregnant.
Lordship says in third page, clearly stated. Doctor say.
The medical papers. From where are you saying?
Medical papers.
6 months pregnant by
The 9 and 10 of my application. Those are the photocopies, and at the end of the brief, my lord, are the certified copies of the same documents.
No, the petitioner is pregnant. Under such circumstances, we enlarge the petitioner on interim bail for a period of 6 months on condition that give a date. Today, 20th. 13th of August.
My lords.
2020, on condition that she shall 10,000 fushiotis.
ACGM Barakpur.
Matter will appear on 8th of August.
8th of August. I'm deeply.
Further report with regard to the petitioner will be filed on that day.
I'm deeply. Deeply.
Next.
Last occasion, you also call for the state report about the progress in trial.
As I was identified in TI pattern, my prayer for bail was twice rejected, lastly on 11th of August. Now, out of total 56 witnesses, till date 2 witnesses who have been examined.
56?
Yes, sir.
What are you going to prove in a case of dacoity? 56 witnesses? How many people identified him in TI parade?
Well, 3 out of 3, 2 have identified him.
Right. So, what 56 witnesses you are examining, Mr. Mitro? Where was the dacoity conduct?
In a petrol pump, my lord.
In a petrol
In a
pump.
petrol.
So, you examine the owner, you examine these workers.
Staff of the.
Then what is this 56? You want a better report with regard to whom you wish to sit with the IO.
Yes.
Report is placed on record. The report is unclear with regard to the timeline within which prosecution proposes to examine witness. Prosecution is also at liberty. In the report, the prosecution may suggest streamlining the witnesses to conclude trial at an early date. Petrol pump. Returnable 2 weeks since.
But the next date is on 1st of March. Can it be after?
All right. Returnable on 6th of March.
6th. I'm ready.
Yes, next matter.
Your Lordship will kindly adjourn it till Tuesday, because when the trial is going on, today is the date also for trial, and thereafter the other dates are there.
When are they? When your schedule is going to come to an end?
Right.
This schedule?
I think, my lord, today is the date, and the next date could be given by the court.
My lord, may I be allowed to submit, my lord? My lord, my prayer for bail was lastly rejected by this court on 10th of November 2022. It was subsequently communicated to the lower court on 15th of December, my lord. Since then, the defense did not take any adjournment. Prosecution had deferred the examination of the witness on 2 occasions, and on 10 occasions, my lord, the witness didn't turn up.
It's a murder case. It's a murder case. Your bail prayer had been rejected in, you said?
Lastly on 10/11/2022.
You give a report with
And with the IC, my lord, I told him, please take interest in this matter, and that's why, my lord, dates are
We are keeping it next week,
next week.
but we want a report.
Very good.
Petitioner is in custody for
more than 2 years, 3 months.
more than 2 years and 3 months. His bail prayer was turned down in November 2022. He contends there is hardly any progress since rejection of bail by this court. He contends there is hardly any progress since then. State shall submit report with regard to status of proceeding and reason for delay. Matter will appear on Wednesday. Wednesday week. Next.
My lord, I am appearing on behalf of the petitioner. My lord, this is that matter where I had sought for interim bail. The petitioner is the mother of 2 minor children. My lord,
has submitted a very comprehensive report.
the children are in custody of the parents-in-law of this petitioner. I had instructions that the mother-in-law is required to undergo a surgery in her spinal cord.
But there is no such indication in the report. There is no medical emergency as such. She has been, she was advised MRI that was done. The doctor whose prescription was annexed, even his.
All right. Report is placed on record. The report shows, though the mother-in-law of the petitioner is under treatment, there is no plan to, there is no plan for institutionalized surgical intervention. Under such circumstances, we are unable to accede to the prayer of the petitioner that her release is necessary to take care of her children who are in custody of her mother-in-law. Full stop. On merits, we note there are ample materials implicating the petitioner in the murder. Full stop. Her bail prayer was rejected in December 2023. There is no change in circumstances since then. Hence, we are not inclined to grant.
The trial may be expedited, Lordship.
Trial be expedited. Yes, next.
Grateful.
May please, Your Lordship. My lord, the petitioner is in custody for more than 2 years and 3 months, but the allegation 448, 325, and 376. But the victim has been examined. My lord, after the framing of charge, 2 years have passed. Out of 10 witnesses, only 2 witnesses have been examined. Victim has been examined, my lord. And the business rival group, both are the cosmetic shop owner. One is wholesaler and one is retailer. For that reason, out of business liability, they have been falsely implicated. And the victim is a mother of 8 years old child, my lord. Is a married lady.
De facto complainant and victim, my lord, examined, my lord. Next date, my lord, 12th March 2000.
Let us see the evidence of the victim.
Then, my lord,
where is the evidence of the victim?
My lord, evidence card can use the copy. আগে থেকে এসেই মনে জীবিত
There is no propose. What is the indebtedness? What were the transactions? The transactions.
Business rivalry, my lord, is happening.
What is the business rivalry? Where
Well,
are
there's the cosmetic shop of the owner of a cosmetic shop.
that is
Well,
nothing.
2 years, 3
Apart
months,
from
more
one
than.
bold statement that there is rival accused were indebted in connection with business relationship.
Yes.
Nothing is there.
Well, 2 years, 3 months, my lord, he is in custody, my lord. But the victim has been examined department. Out of 10 witnesses, within these 2 years, only 2 witnesses has been examined. Charge was framed, my lord, on 23rd December 2021.
In
The examination
PW1,
starts
PW1, did you bring out anything with regard to dues, pending dues? Nothing.
No, that is not, that is.
Then not a fact that I were under date from accused person. Where was the date? When was the date created?
That
Is
is not
that
what
should be some foundational facts should be
due
laid,
to
na?
business rivalry.
That there were earlier business transactions, there were dues.
Oh, that is that I there. The father also admitted that they are the business transaction.
Where?
Now, kindly see that there is a business transaction that is there.
Where?
They used to purchase material.
Correct. That he purchased from this accused. Where is it? The only thing is local cross-examination that there are other shops, so they could have been alerted when she shouted.
Nothing is there.
There is nothing.
And nothing has been seen.
On the other hand, the injuries is there on her.
No, 2 years, 3 months, victim has been examined. Kindly consider, madam.
Petitioner is in custody for more than 2 years. He submits that vulnerable witnesses have been examined. He prays for bail. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. We have gone through the evidence of the victim as well as her father. Full stop. Apart from a bold suggestion of false implication due to outstanding dues, no material to show there were prior business transactions or business/loan transaction between the parties was elicited during cross-examination. On the other hand, victim stated that she was forcibly raped. She suffered injuries. Medical reports are also on record. Under such circumstances, we do not consider it prudent to release the petitioner on bail. Rejected. Trial be expedited, concluded within 1 year from the next day. Next.
Empathy petition. 302 allegation under section 302 lordship. 4 years 9 months he is in custody, lordship. Only earlier occasion the charge has been framed. 17 witnesses is there. Land dispute between the parties and
mother-in-law chopped the sister-in-law in front of the villagers. Thereafter,
no, there is no eyewitness.
He straight away went to the police station with the blood-stained sword.
But all
Yes,
these
sir.
things, when will they come in evidence?
My lord, my learned friend has not annexed any orders. The reasons of delay, I couldn't find.
You give a
Next
report,
day,
let him annex the
Yes.
supplementary affidavit enclosing order sheet endorsing delay. Petitioner contents he is in custody for more than 4 years. He
4
prays
years,
for
9
bail
months.
on the ground of delay. Supplementary affidavit enclosing order sheet endorsing such submission be placed on record. State shall also submit report with regard to reason for delay. Adjourn 2 weeks.
2 weeks.
Next.
May I please your lordship? Lordship 302 is there. Out of 18 witnesses, one has been examined till date, and that is on 19th of February 2022. Co-accused has been granted bail, and that
We are
time
not
also.
standing on the same footing, your lordship, because specific allegation against this present petitioner, he is the one who dealt the severe blow, your lordship. There are several eyewitnesses, 164, your lordship.
Only the de facto complaint has been examined till date,
And
and that is on
weapon
19th
also
February.
seized. Offending weapon also seized from him.
What is the materials against him?
Yes, your lordship. Eyewitnesses 164, offending weapon seized from
He assaulted,
Yes, specific allegation against him, your lordship.
not Dilip.
No, they were there, but he is the main person who had dealt the severe blow, your lordship.
Petitioner petitioner is in custody for
3 years.
3 years. He contains co-accused. Dilip Ghosh has been enlarged on bail. He prays for bail. Learned lawyer for state submit. Petitioner is the principal offender. He had dealt the fatal blow on the victim. We have considered the materials on record. Petitioner had dealt a fatal blow on the victim. Full stop. He is the principal offender. He does not stand on the same footing with co-accused Dilip Ghosh, who was enlarged on bail. Under such circumstances, we are not inclined to grant bail to the petitioner.
The trial may be expedited, my lord.
Trial be expedited.
Great.
Next.
I am for the petitioner, my lord. The service has not been completed.
We have considered the materials on record. Bail prayer of the petitioner was rejected on merits in October 2023. Allegations involve rape of a victim. Oh, anticipatory bail.
Yes.
Sorry.
Offense under section 376, my lord, delay in FIR, my lord.
This is a 164 statement of the.
All right, give a notice. Notice upon the victim.
Yes.
Adjourn 2 weeks. Next.
My lord, I have a petition, my lord. For 363, 368, 370, my lord. The petitioner is the actual victim, my lord. The petitioner's son has been, my lord, recovered by the police, my lord. My lord, the petitioner admitted for delivery for Adashokti nursing home, my lord. Subsequently, he was discharged. My lord, the nursing authority, my lord, said that her son was dead, my lord, and discharged, my lord. Subsequently, my lord, petitioner found that his son is, my lord, recovered by the police, my lord. She went to the police station, my lord. Subsequently, she was arrested, my lord.
This is totally wrong submission, your lordship, and this is, she is the source. When she goes to the nursing home with her sister-in-law, minor sister-in-law, and there, my lord, first she attempted to abort the child. The doctor said, if you abort, your life is in danger. Then she gives delivery to the child by taking along with her, my lord, her younger sister-in-law. And thereafter, she comes all out. And there are CDRs and SDRs which shows she was having direct contact on the day of delivery and after the delivery, my lord, with persons who are, my lord, involved in this trafficking of minor newborn child.
She do.
No, my lord, your lordship will kindly see, will not adjust you. Your lordship will see, my lord, she has paid the money for the nursing home. My lord, it is she, but and no one has come forward. The family also, my lord, has not come forward. She has given a story, my lord, as given by my learned friend, that the stillborn was, but actually it's not. So, mother, my lord, who can, my lord, first try to abort the child, thereafter, my lord, hand it over to, well, she is aware of those persons who are involved in this trafficking of newborn babies.
And one, my lord, only my lord, the owner of the Adashokti, my lord, nursing home, his name was not charged in, my lord.
The owner, my lord, the doctors, my lord, even there's a statement of the doctor who had said, my lord, I did not, the endorsement was taken from me, my lord, later on, subsequently. A mother, my lord, a newborn child, girl child, my lord. After seeing the face also, my lord, she has got the, my lord, that much of thing, my lord, to hand it over to a trafficker. Then also by calling him. And this would not have been known, my lord, because the person to whom the newborn child was given custody, my lord, for keeping it interim period before the customer could be found. My lord, the neighbors found the childless couple, my lord. The child was weeping. They became suspicious. They went and asked them. They could not show any documents. Then they informed the police, my lord. Police came and asked them, from where did you get it? Then the nursing home name was revealed. And this lady, my lord, with whom she had gone for the delivery, is the sister-in-law. She had said, like,
who is the father of this child?
Sofikul, my lord. I'm written, my lord. Must take Sofikul, my lord.
Who is Sheikh Sofikul?
My husband, my lord.
Your husband?
My lord.
Did you have a DNA test of the child?
No, it has been said, madam. We have not got the report yet.
Let us see the DNA
Yes.
report. DNA report with regard to the traffic child be placed on record. Adjourned, how long will you take?
4 weeks.
4 weeks. Next.
Deep
Supply to poverty disadvantage. Real process. Oh. Yes, next matter.
Below, I am for the petitioner. Below the allegation under section below 302, 392, 326. Below, I am in custody. Below 8 years and 8 months. Below, the prosecution had examined 41 witnesses. Below, the dates fixed for below delivery of the judgment below 15 days throughout last year. Below, the date was fixed for delivering of judgment. Below, the judgment has not been.
The argument completed in the month of January 2023. Thereafter, my lord, the judgment was not delivered. My lord, on every occasion, judgment not ready, judgment not ready, judgment not ready. On 4th January 2024, the judge got transferred. Now, my lord, the court is vacant and learned second judge, Krishnanagar, my lord, he has taken the charge. And my lord, the next date fixed for delivering of judgment is on 29th February.
Yes, the arguments have to be done afresh,
That's true.
isn't it? The judge is transferred. When the arguments were completed?
My lord, in the month of January 2023. 31st January 2023.
And then the judge was transferred in 24.
3rd January 2024.
All right. Petitioner is in custody for 8 years.
8 years, 8 months.
8 years, more than 8 years, 8 months.
29, the judgment will be delivered.
Huh?
The judgment will be delivered as I got information from the investigating officer on 29th of this month. The judgment will be delivered.
He submits there is delay in trial. Learned lawyer for state submit that date has been fixed for delivery of judgment on 29th of February 2024. Under such circumstances, let the matter appear for hearing on 6th of March 2024. Next.
My lord, it's a renewal of my application. Earlier, it was rejected in the year 2020, wherein, my lord, only charge sheet was filed. My lord, subsequent to that, my lord, 15 of the prosecution witnesses have been 15 witnesses have been examined. My lord, kindly have a look at the depositions, particularly, my lord, PW1, the de facto complaint. After receiving notice, I have come to court for deposing the instant case. Even after receiving notice, I failed to understand in what matter court called me. My father's name is Sonwa, who is no more. I cannot say how my father died. This is my signature in the written complaint, but I do not know when and where I put my signature there.
Who are you?
My lord, I am the third wife of the deceased.
Third wife of the deceased.
And the deceased was staying with her only, your lordship. When they found the deceased, then her hands were tied up and she was there. All of them stated that she was there in the room with the deceased.
Who was she?
She's the third wife of the deceased, your lordship.
Okay.
Well, there are other two co-accused persons who have already been granted
people
bail.
also in the house, no?
But she was sitting in the room. She is the one who
All right.
out of her, you are
Petitioner is in custody for
3 years and 8.5 months.
More than 3 years, 8 months. He submits most of the prosecution witnesses have turned hostile. She prays for bail. Learned lawyer for the state contends petitioner was one of the wives of the deceased. She was found in the room where he was murdered.
There were call detailed record also with the other co-accused. She
Oh,
was continuously talking.
We have considered the materials on record. It is materials on record. Petitioner was not the only inmate in the house. Full stop. The prosecution witnesses have turned hostile and not supported the case. Full stop. There is no possibility of the trial concluding in near future. in view of the scanty evidence on record and as the implication of the petitioner in light of the witnesses turning hostile is based on surmises and conjectures, we are inclined to grant bail to her. 10,000 per court.
Additional District Judge Chanchal Mal. Additional Session Judge Chanchal. I'm grateful to you.
Well, I am renewing this application, my lord. I'm in custody 1 year, 1 month, 7 days. Earlier occasion, your lordship turned down my application. Till date, only charge sheet submitted, copy is not ready, commitment not yet been done. One co-accused Biplov was granted bail, who was also identified in TI parade. The reason is that within 1 month I was identified and he was identified after 6 months. Now,
Bail prayer of the petitioner was rejected in February 2023. What is the progress in the matter since then?
The charges submitted in the month of August.
May was rejected. How can it be in August?
October, your lordship last rejected October.
Last.
And thereafter, copy.
Identified at the time of occurrence, my lord. Kindly see the page 2.
Bail prayer of the petitioner is rejected in October 2023. He was identified by witnesses in the course of TI parade, which was held immediately after his apprehension. He cannot claim parity with co-accused, whose identification was 6 months after the incident. In view of the co-accused bracket who is on bail. Under such circumstances, we are not inclined to grant.
Well, the copy is not yet ready. Yes, commitment has not been done.
Next.
My lord, I am for the petitioner, my lord. It is a case under section 498A, 406, 494, 467, 468, 471, 506, 34.
How long you are in custody?
My lord, 14 days, your lordship granted bail to the petitioner, son of the petitioner, who is the husband, my lord. That is at page 34, my lord. And there is no allegation against the father-in-law, who is the petitioner before your lord.
Petitioner is the father-in-law of the de facto complainant. Principal husband of the de facto complainant has been enlarged on bail. Keeping in mind the aforesaid fact and extent of complicity of the petitioner in the crime, we are inclined to grant bail. Allowed. Next.
CJ Malik.
ACJ Malik.
Yeah?
ACJ Malik.
ACJ Malik.
Yes.
May it please the Lordship. My lord, this is the service to the victim girl. My lord, the petitioner came to, and the victim girl, my lord, came to know each other through a gaming app, Hago. And now, my lord, they fell in love. My lord, your lordship.
Statement of the victim. Service is complete.
Yes.
Statement of the victim.
My lord, kindly. Okay.
Any photograph recovered?
Page number 27 to 31.
Petitioner contends that.
May I only trouble your lordship for a minute, my lord? I know your lordship will park. My lord, this petitioner is a resident of Bihar. My lord, they came to know each other through a gaming app. my lord, this victim girl, my lord, she had called him. My lord, to
She can do anything, but this does not give you the right to forward her pictures to her brother.
but that was not forwarded as per instruction.
They have been forwarded.
I'll go down to your lordship.
Petitioner contends there was free mixing between himself and the victim girl. Subsequently, she has falsely implicated him. He prays for bail. And a lawyer for the state opposes the bail prayer. She contends victim had been blackmailed by circulating her objectionable pictures, her intimate pictures to others. We have considered the materials on record. Petitioner made the victim over a gaming application on the internet. Thereafter, he had surreptitiously taken intimate pictures of the victim. When she fell out, when she did not wish to continue the relationship, petitioner had forwarded the pictures to her relations and had also threatened to blackmail her. Documents collected during investigation support the allegation. Under such circumstances, we are not, and as victim is yet to be examined, we are not inclined to grant bail at this stage. Yes, next.
Well, I am for the petition. 304/34 of the Indian Penal Code, my lord. I am in custody for 1 year. This is my renewal of bail prayer, my lord. Since there is no progress in before the trial court, charge has not been framed.
Petitioner
2% charge sheeted.
that he did not have
One is on
intent
bail,
to
my lord.
murder the victim. There is delay in trial. He is in custody for more than a year. He prays for bail. And a lawyer for the state submit petitioner had assaulted the victim, resulting in
The victim died in his house, my lord, 6 hours after, my lord.
Father and elder brother killed his son and brother.
Huh?
Father and elder brother killed his victim.
We have considered the materials on record.
And recovery of the weapons.
It's a charge of 304. We have considered the materials on record. Petitioner has been charged with the offense under section 304 IPC. He did not have intention to murder the victim. Though he is in custody for a protracted period of time, there is slow progress in trial. Under such offensive proof, even if proof would not attract mandatory life imprisonment, there is no chance of abscondence. Accordingly, we are inclined to grant bail.
I'm deeply
Next.
Well, I'm for the petitioner. But I am renewing my prayer for bail. 6 months back, my prayer was rejected at that stage. I am the husband. I am now in custody for 1 year, 1 month. The 498 304B. The allegation was that some poison was poured in the mouth of the housewife.
We have considered the materials on record. Petitioner husband had poured poison in the mouth of his wife. She suffered homicidal death. Bail prayer has been rejected earlier on merits. We find no ground to enlarge the petitioner on bail at this stage. Next.
Mate, please, your lordship. I am appealing for the petitioner. My lord, it's a case under section 302 of the Indian Penal Code. My lord, initially in the FIR, my name did not transpire. My lord, this incident takes place on the 1st of September 2023. On the 2nd of September, I am arrested on the basis of a statement by the daughters of the deceased, of the murdered person, that I had a quarrel with him about 7-8 months back. And about 3-4 months prior to the incident, the father had said, if something happens to me, you suspect this person. This statement was recorded on the 1st itself. I was arrested on the 2nd.
The person who assaulted is Abu Hussain.
Yes, he is my brother. That's why I'm being implicated. After about...
You are Abu's brother?
Yes.
Ali.
I am Abu's brother, Ali Hussain.
You are Ali.
Now, after 8 days of my arrest, my lord, 2 persons come up. That is CS charge sheet witness number 11 and 12, they say that I was present at the spot. I was in a dark place. When this person came, I gave a signal to my brother. My brother thereafter hacked him on the neck, and I fled. He thereafter fled away on the scooty.
This can only be seen during trial. The probability of this witness.
Well, after 8 days of my arrest, this comes up. And after 23 days, another statement is taken of another charge sheet witness number 14, who says that he saw me conversing with my brother on that date at about 5 o'clock.
Is there any material to show that you had animosity with the...
Well, except the statements of these daughters. Well, I have taken out the relevant witness statements. Your Lordship can see the same. Well, I have the 207 papers, and I am in custody for 163 days, 65 days.
164, Malad. The next 161 and 162 are the two independent eyewitnesses, Malad.
But kindly sees the date on which they are being examined. They are examined on 10th of September. I am arrested on the 2nd of September.
And Malad, moreover, while murdering Malad, one independent person's CCTV had covered everything. Malad, that footage is there. Malad, we've got it.
But that does not implicate me.
I submit for the de facto complaint. This petitioner had taken active role in the commission of offense. My lord, he was waiting at the doorstep of the victim's house. My lord, when he came out to make his prayer at the mosque, evening prayer, and he was waving his hand to indicate that the victim has come out to his brother. And his brother cut the throat by coming with by a scooty with another co-accused person, Mohammad Miraj.
All of them are known to each other. Why would I need to give a signal to a record? It's, well, they're all of the same place. So why would I need to show the person, identify the person?
Statement of 5 witnesses have
What
been
is he
recorded,
saying?
judicial statement.
That you are not a mercenary. You are a brother. You know the victim as much as he does.
What was that at that point of time? What was their requirement? I do not know. Because I did not.
The requirement was of the prosecution to implicate him. That is why after 8 days, someone comes and says that he was waving at the principal accused.
Eyewitness version, my lord. Eyewitness version.
Huh?
Why did one local grocer also given statement, what I have gathered from my...
That is what we are saying. Appears that he was in that locality.
Initially, the case was investigated by the local PO. And thereafter, it was transferred to DD. Thereafter, statement.
Or something.
Well, 163 days, Malad.
163 days is nothing.
But kindly considers, Malad, how I am being implicated.
There's nothing contains that he is in custody for 163 days. He has been falsely implicated. He was not named in the first information report. Due to animosity, he has been falsely implicated. Statements of witnesses implicating him were belatedly recorded. Full stop. He prays for bail. Learned lawyer for the state opposes the bail prayer. Learned lawyer state and de facto complaint oppose the bail. Huh? 164 statements about saying that he was standing there. How can you think the statement? We understand that this during trial he can cross-examine and all. But in fact, all the three, it has been developed by the CID after. We have considered the materials on record. FIR was registered by FIR was registered. Informant who registered the FIR was not an eyewitness. Full stop. Investigation in the instant case. During investigation of the instant case, eyewitnesses were recorded. They stated that petitioner was at the place of occurrence and had indicated the presence of the victim to his brother. What is his name?
Abu Hussain.
Abu Hussain, who murdered him. The petitioner had animosity with the said deceased. Full stop. Delay in examination of eyewitnesses per se is delay per se is no ground to disbelieve the statement of eyewitnesses, and that too at this premature stage when evidence has not come on record. Under such circumstances and in view of gravity of offense, we are not inclined to grant bail at this stage. And the other problem is, if I am not वो eyewitness होता है, कुछ contradiction आता है.
Now to pay it.
61.
But there are 6 petitioners. They are in custody for 3 years, 8 months. But on ground of long detention, your lordship had already granted bail to the other co-accused persons.
Then we give you bail on parity. Petitioner is in custody for more than 3 years.
3 years, 8 months.
He submits there is inordinate delay in trial. Co-accused has been enlarged on bail. Petitioner is entitled to similar relief allowed.
Grateful to your lordship.
উৎপল মল্লিক এটা অর্ডার দিয়ে দেবো
What a long signal. Go on continuously. Next.
I am for the petitioner. The petitioner surrender from the surrender and now 125 days custody. The 11% granted bail. 3%
custody for more than 500 days.
206 days. Kindly see page 14.
125 days.
Kindly see page 14, 14 and 12.
Come up after 5. We are telling you, come after 500 days, we'll give you.
Kindly 206 days.
But
Kindly
you come after
kindly 206 days.
You come after 206 days, not pressed. Because the next will come up at 80 days and say that you have given him at 100 days. All right. Next.
I am for the petitioner, my lord. I am not pressed the application.
Oh. They are afraid of you. Huh? Not pressed. Next. इसका बाप को खाया
Milord, I am for the petitioner. Milord, the offense under section 376, 3, 420, 406, 465, 471. Milord, I am in custody. Milord, 1 year, 11 months, 8 days. Milord, the
victim examined
all 6 witnesses, including victim, mother.
6 witnesses has been examined out of 15. Earlier rejection, your lordship.
All right. When do you finish the case?
Lordship, within 6 months, I think.
All right. Petitioner prays for bail. Petitioner contends he is in custody over a year. He prays for bail and a lawyer for the state submit. 6 witnesses have already been examined. Allegations involve penetrative sexual assault on a minor. Offensive proof would attract imprisonment not lower than imprisonment not less than 20 years. Would attract 20 years rigorous imprisonment. Trial has considerably progressed. Under such circumstances, we are not inclined to grant bail. Trial court is requested to expedite that.
Milord, 1 year, 11 months.
For about 2 years.
Man.
Next.
Wait.
63.
Yes.
Hey, sorry.
Yes, my lord,
65.
for the petitioner, the offense under section 395, 397.
How long you are in custody?
I'm in custody 2 years, 60 days.
60 days will not do.
Trial is going on.
So
Next
the
date are 19th and 20th of this month. 5 witnesses has been.
When is the date?
19th of this month and 20th of this month.
Let this
5
matter.
witnesses
Let this
so many
matter
dates have been
appear.
elapsed.
Huh?
So many dates have been elapsed.
Correct. We granted 2 years, 3 months. Now there is a date. We will keep it after 1 month and see if the evidence is going on. Matter will appear on 11th of March 2024. Petitioner prays for bail on the ground of delay. We are informed date has been fixed for, schedule has been fixed for examining remaining witnesses in February 2024. Matter will appear on 11th of March 2024. Status of the proceeding be filed on that day. So next. Jaki Saha.
My lord, I am for the petition, my lord.
15 Foreigners Act, my lord, I have annexed the
Annexed. Report be filed. With regard to the petitioner contents, he is a Indian citizen. He relies on voter's identity card and other documents in support of his plea. State shall submit report with regard to authenticity of the document and adjourn 2 weeks. Next.
My lord, after 15 years of marriage, the husband found suffered an unnatural death. The wife and all her family members, they are implicated. He is the Meshomoshai. 164 statement, my lord, I find from the boy.
He was there. Lordship, kindly.
So he may be there. So what?
But
No,
in
kindly see this
What we will.
statement of son of 12 years.
Son of 12 years.
Yes, Lordship, kindly see what he has done.
201 only.
Also 95.
And 95, 164 of the son.
Same thing.
Deepak Chaudhary is the Meshamosai. সকলে মিলে পা ধরে বাবা টানতে টানতে পুকুরে ফেলে দেয় আফটার মার্ডার
After murder, then
মা দিদা দীপক চৌধুরী মিডল পোর্শন লর্ডশিপ কাইন্ডলি কনসিডার
how did he die? Postmortem?
Postmortem, lordship will find
all drama. Suicide होगा
157 postmortem. And 164, page 95.
নোড়াটা পাওয়া গেছে।
তোমাকে দেয় কি?
কার কাছে?
এ থেকে পাওয়া গেছে।
কোথা থেকে?
থাকবে।
দেখো কোথায়?
না না।
postmortem তোমাকে দেয় কি?
64 কি সিস্টেম আছে কথা
And kindly see the photograph of the victim. Blood 133. 133.
Intra multiple linear abrasion of right left knee waist. Lacerated injury.
Result কত পাবে?
Lacerated injury in the forearm and right parietal region.
এটি নোড়া পাওয়া গেছে ওটা কি
There is no finding in respect of the brain here. What is the writing? Intracranial hemorrhage. The area with regard to the head and scalp finding is completely blank. Who is this doctor?
And seal Noramla doing fire.
Pramod Sarkar, medical officer, Dungipur
Silnora will come later on. Let us see this doctor's opinion.
Opinion
and
the internal examination of health and skull, the head and skull, all the notings are blank. And he is saying that death is due to IC hemorrhage. At the bottom, there is 1.5 IC hemorrhage. Where is the hemorrhage? If there is an IC, as we understand, it may be an intracranial hemorrhage, then the noting should be there in the brain findings. There is nothing, no noting. What is the cause of death?
I'm like 95, not 164 kindly.
164 will come later on. If the person did not die because of assault, then those eyewitness will have no relevance.
Kindly see the photograph of the victim. 133,
So we will become a doctor and see the photograph of the victim.
No, not kindly similar. For the
One-
purpose of 133. চলে গেছে
Petitioner is in custody for
64 days.
64 days. Investigation going on.
No, charge sheet is filed.
Receipt file, next date 22nd February for production. 22nd February. And 164 specifically named.
What does it show? 160 post-occurrence activity.
With bloodstained blood.
He was dragging, but then there is no evidence.
Not dragging with blood.
There is no evidence who assaulted. Isn't it?
But Your Lordship kindly consider that this is a bail application.
Petitioner is in custody. Petitioner is the maternal uncle-in-law of the deceased. He
No.
brother-in-law.
Brother.
Petitioner is the brother-in-law of the deceased. He contends he has been falsely implicated in the case. Investigation is complete. He prays for bail. Learned lawyer for the state opposes the bail prayer. The content petitioner and others were seen dragging the victim who suffered bleeding injuries and throwing him in the pond. We have considered the materials on record, including the PM report. Full stop. Allegation, including the PM report. Full stop.
PM Millard 157.
Though the PM report notes death due to IC hemorrhage, there is no noting in the columns titled head, skull, meninges, and neck and brain findings. At the bottom of the report, it is endorsed 1.5, half, and half IC hemorrhage. Full stop. Although it is alleged that the victim was dragged and thrown into a pond, no water is noted.
Beside the blood at the bank of the pond.
পুকুরে আমার বাবাকে ফেলে দিল বাড়ির সামনে পুকুরে আমার বাবাকে ফেলে দিল
Body was bank on the pond.
FIR on clause that he was falling bank of the pond.
So if the witness says that it was thrown into the pond, doesn't that run counter to your FIR? Although the witness claimed that the victim was dragged and thrown into the pond, it is strange that it is incomprehensible that the body was recovered from the body was recovered on land and there is no water found in the stomach or lungs of the victim. Full stop. They are possible even without prejudice to the aforesaid. Now, even if the said statement is believed, it merely discloses a post-occurrence conduct of the victim in dragging the body of the deceased. Full stop. Keeping in mind the aforesaid inconsistencies, we are of the opinion petitioner may be granted bail. Next, Yes, senior government advocate. Today, how long will you work? Today up to 3:30.
3:30.
Okay.
ওই এসিজিএম জঙ্গিপুর।
This is for Mr. Sunil Chakraborty.
Next, my lord, this petitioner, she is a lady. My lord, she is the reason for elimination of her husband.
Takes it for pride.
Right. Next.
Hello.
I have seen, my lord, but not received. My lord.
All right. Notice we issued upon the victim. Adjourn 2 weeks. 70.
70. Lord, I am praying for bail in terms of section 167(2) of the Code of Criminal Procedure. If you Lordship kindly turn to page 18, that the order passed by the learned additional sessions judge, my lord, the entire facts will be clear before your lordship. Page 18, annexure P5. Initially, the case was registered under section 489B and C. But although the UAP Act not there, the IO prayed for, my lord, the extension of time. And my lord, subsequently, when the statutory period was about to, my lord, over, my lord, he filed, my lord, this prayer under section, my lord, the 15 of the UAP Act, that by the sub-inspector, which is not permissible under the law. Now, my lord, my statutory bail was rejected and the prayer for further investigation allowed and UAPA was added on the same day. But there are two irregularities. When, my lord, the extension was sought for, but at that point of time, no UAP Act was there, only 489B and C. Second, my lord, the sub-inspector of police doesn't have any power to, my lord, pray for my lord, the addition of section, my lord, the UAP Act. But these are the two ground, my lord, both the ground, my lord, both my point was, my lord, the before the revisional court, and revisional court was satisfied about my, my lord, the prayer which was I have submitted before the revisional court and accepted that, my lord. And now, since then, the entire record, initially it was sent to the learned sessions judge. Now, sessions judge will not send the matter to entire record to the NIA court, Kolkata. Now, there is a confusion which court has the jurisdiction. Now, the learned sessions judge, Murshidabad, has sent the entire record to the our court, High Court, for a revision. And that is pending. And my statutory bail is stuck there for last 3 years.
But you were granted statutory bail?
No, but my prayer was rejected. I filed a revisional application.
They allowed you?
No, they set aside both the order, but did not, I did not pray for bail. So, learned additional sessions judge did not allow the prayer for bail. Only allowed those two, set aside those two orders.
You give a report?
Charge sheet has been submitted by the Deputy Superintendent of Police.
That is subsequently.
Please give a report. Or this theoretical thing, give a response. Petitioner prays for statutory bail. State shall submit response to the plea on the adjourned date. Adjourn 2 weeks.
My application, my lord. I'm in custody for 8 years, 1 month. My lord have granted bail to the co-accused. Page 72 of my petition, my lord.
Petitioner is in custody.
Stand in a different footing with that poet.
My lord, kindly peruse the order, my lord. Page 72. And last.
Tumpa is altogether in a different footing.
Yes. Kindly see. Last witness in 2021.
Petitioner is in custody for more than 8 years. He submits that his inordinate delay in trial. He prays for bail. And a lawyer for the state submit. Petitioner stands on a different footing from co-accused Tumpa Molli. We have considered the materials on record. Bail prayer Tumpa Molli, bail of Tumpa was enlarged on bail on the ground of inordinate delay in trial. This circumstance applies with equal force with regard to the petitioner, irrespective of his extent of complicity in the crime. The circumstance which weighed with the court to grant bail to Tumpa applies with full force to the petitioner. Under such circumstances, we are inclined to grant bail to the petitioner. Also allowed. Yes, this 2 p.m. matters, we'll take it up. But today, 3:30, we don't know whether we'll be able to do these 2 p.m. matters. Keep it maybe next week. All right. Admission of appeal, who's there? आज ये करना मुश्किल है. That's सुना ना. Let us keep it on. Nobody appears out of list. Liberty to mention. Next. '86, Mr. Nandi, defects removed.
Not check the.
Please check the defects. What is the defects? Section 5. Oh, they have filed section 5. A copy of the application under section for condonation of delay be served upon opposite party number 1 to opposite party 1 to 6 to registered post with acknowledgement due matter will appear 6 weeks hence. Other matters are to pay.
Yes, yes. No, I was.
I think other matters are there. Your matter will take it next week or some other day.
Next Tuesday.
Other parties have been notified, Mr. Parks. You are appearing for all of them?
Not for all the de facto complaints.
Whoever, but then they are notified.
Well, this is the report.
Tell us when you want.
Next Tuesday, madam.
Huh?
Whenever you launch.
Next Wednesday week.
Wednesday, Wednesday week, some difficulties are there. Wednesday week, Thursday. Thursday week. Written notes দেয়নি ওটা report দিয়েছে really funny. I was thinking that I will seek for the adjournment because my junior Mr. Bhattacharya is not here.
Mr. Bhattacharya.
And depending upon him, if I do, I
This
can't.
week he will not be there.
Hmm?
This week he will not be there, he said. We said we'll keep this week just to get the report of notification of the de facto complaints. Public prosecutor submit report. De facto complainants have been notified with regard to the pendency of the proceeding. On the prayer of the parties, matter is fixed for hearing on 22nd.
Maybe get a leave to file an opposition to the bail application. If prepared.
To prepare and give it doesn't matter.
It will serve upon them and the state and it will file.
Opposition, if any, shall be filed by.
They are ready. Let them give it today.
You're ready?
Yes. We have the. Yeah.
By Friday. By Friday, reply, if any, by the urgent date.
Right.
All right.
Wait.
Yes.
Give love, Yes.
Next, bail in connection with appeal. My sessions are on 26th and 27th. So 28th, I'll take the flight back to Calcutta. So I can join earliest 20th. I'll be calculating. Let's start on 22nd and then 25th. आज तो आप ही चलेगा कब दो दिन है नहीं है उसके पास उसके अंदर 22nd फर्स्ट एंड सेकंड 29th and
87 back हो जाएगा
this week brother is find the profile of the one of the other. It's not like a general concentrate. Those yeah. Otherwise, there is other. Went for cancellation, but is very clearing. Yes, 87.
Well, at 87, I am for the appellant minute. The principal accused has been granted bail by your lordship. Lordship would kindly.
87 lordship. Principal accused is already in bail.
But page number 103 is your lordship's order minute.
Appellant is in custody for
10 years and 11 months. Around 10
about
years.
11 years. Co-convict Shambhunath cow has been enlarged on bail. He prays for suspension of sentence and bail on parity. Learned public prosecutor submits. Appellant was appeals are ready for hearing. We have considered the materials on record. Victim was a cardiac patient. In the course of scuffling and overexertion, due to scuffling and overexertion, he due to pushing and overexertion, he died. Even if the evidence on record are believed, it is difficult to conclude that appellant had intention to murder the victim. Under such circumstances, co-appellant Shambhunath cow has been enlarged on bail. Appellant is entitled to similar relief.
Extremely rare. There is only crime in 87.
Even if the evidence on record is believed. Next.
No, I am for the appellant, my lord. Your lordship. On 8th February 2022, your lordship rejected my application, my lord. Now the appellant is in custody for 4 years. It's a case, the one person found with multiple injuries in a railway quarter. He was taken to the hospital. Later on, he succumbed to the injuries. And it appears from the
Appellant bail prayer of the appellant was rejected earlier on merits. He is in custody for 4 years. He renews his prayer. Paper books are ready?
No.
Paper books are ready. There are ample evidence on record implicating the appellant in the offense. He has been sentenced to life imprisonment. Paper books have been prepared and appeal is ready for hearing. Under such circumstances, we are not inclined to suspend the sentence of the appellant. Let the matter appear under the heading, paper books be collected. Matter will appear under the heading hearing in the monthly list of April 2020.
Next.
Lordship, I beg to appear on behalf of the appellant. The appellant is convicted under section 20B2C of the NDPS Act, imprisonment for 12 years. He is already in custody for about 3 years and 6 months. And what Lordship, there is yes, paper book is ready, and Lordship kindly sees the judgment once. Page number 30. There is clear indication that violation of 52A of the NDPS Act is there.
Here, my lord, the
Kindly see page number
Alamat was
53.
produced at the time of my lord the trial.
Alamat may be produced, but 52A compliance with regard to the sample. That has to be done.
No, Lordship, may kindly see page number 33 once
My lord,
at the
kindly see, my
bottom.
lord, page 25, my lord. It has been
Let us
stated-
first see what he is indicating. Let us see.
Page number 33, Lordship.
in the present
Page
case,
number
the contravent
33 of the judgment.
33.
33 of the paper book, Lordship.
paper book.
Internal page of the judgment teller.
Nice, Lordship. At the bottom, admittedly, in this case, there has been no compliance of section 52A of the NDPS Act, which speaks for correctness the certificate of the seized contraband.
Appellant is in custody for
3.5 months. 3 years and
3.5 years. He submits there is no compliance of section 52A of NDPS Act. He prays for suspension of sentence. Paper books are not ready.
paper books are ready.
Acha. He prays for suspension of sentence. Learned lawyer for the state contends seized alamat was produced in court. Witnesses have deposed that recovery was made from the appellant.
22.2 kg from the poison of the appellant.
22.2 kgs of
From the gaja, from the
Gaja
exclusive
from
poison of
appellant.
the appellant.
We have considered the evidence on record. Though witnesses claimed contraband was recovered from the appellant, comma, no sample was drawn in the presence of the magistrate. Chemical report chemical report received during trial was based on samples drawn at the spot, which is impermissible in view of Union of India versus Mohanlal. In light of the law declared in so and so, sample drawn in the course of inventory under section 52 capital A requires to be examined by chemical examiner. This is in view of the aforesaid lacuna pointed out on behalf of the appellant. We are of the opinion an arguable case in appeal is made out. Appellant has suffered incarceration for more than 3.5 years. Under such circumstances, we are of the opinion appellant has been able to rebut statutory restrictions under 37.
Only one thing, my lord, I submit, my lord. My lord, in page 25, my lord, it has been observed by the court, trial court, during the lengthy cross-examination, defense fails to elicit anything from the mouth of the pleader to show that the case property has been tampered with. Learned defense counsel failed to show that what prejudice has been caused by the accused person for non-disposal of the property.
No,
Ah,
the
so, my
sample
lord,
was not drawn in.
my lord, so when the sample has been sent and my lord, the alamat has been produced, during that period, my lord, there is no.
You see the Supreme Court decision, it says that it must be from the.
Well, that I know, my lord, that the spot. Not from the before magistrate, my lord, it has been. That I know, my lord. But fact is, my lord, here, my lord, there is
The
no
Supreme Court did
no tampering.
The Supreme Court did not incorporate a prejudice rule.
Before magistrate, my lord. The sample has to be taken before magistrate. But whether, my lord, that has been prejudice to the accused or that
again
any tampering of
we are harping on you. Was the prejudice rule applied by the Supreme Court in that judgment? We'll examine it during appeal hearing. As of now, let him be on.
Here, my lord, even my lord, the 436A concept, but the Supreme Court decision of the legal aid committee, that is not, my lord, the
We have not applied that. Have we applied that?
No, my lord has applied only on the basis of the, my lord, the non-compliance of section 52.
Absolutely. During trial, it could have been your responsibility. Take out an application.
So, my understanding, my lord, the section 52A 2 or 3, my lord, if it is not complied as a primary evidence, my lord, if it is produced at the time of trial and there is, my lord, no evidence of tampering and the accused has not been prejudiced, my lord, then the question of compliance of section 52 is mandatory or not, my lord, I am asking my.
First, it is mandatory because of Mohanlal. Second, as you are arguing, there is a lapse in investigation. 52A is not complied with. Your prosecutor produces the alamas. Why doesn't he take out an application that here and now do 52A, get a sample and send it for examination? What stopped you from doing that? What stopped you? Second thing, alamat being produced, but the sample is not sent from that, drawn from before the magistrate.
But the chemical examination report says the sample is intact. And
correct, but which sample is sent? It depends on the ipse dixit of the investigating agency or raiding party that we drew sample. That is where Mohanlal intervenes. He says, to be safe, let the sample before the magistrate send for examination. For argument's sake, police officer bungles. Why does not the prosecutor make an application? Sir, there has been some lapse. 52A sample has not been sent. Please direct the sample drawn before the magistrate, or please direct compliance of 52A. He couldn't have stopped that. So, the failure is investigation, failure is prosecution. So in appeal stage, we will give him the benefit.
Grateful.
Satisfaction of special judge Ali.
अभी हम नहीं देते हैं. Court साहब एक judgment देते. I was following what he's saying. That's why he's arguing that अगर वो seal है chain of custody ठीक है, tampering क्यों करे? ये सब इतना नहीं आता.
My lord, in 94, my lord, I gather Mr. Nundi is for the state. Oh, sorry. My lord. Sorry, time check. Password check. Aste, aste. Take your time.
Short passable for sir.
No, Monday. Monday. তাহলে তুমি দাদা মঙ্গলবার হ্যাঁ আরে বল না কোটকে ধরিনি ডাকিনি অটো স্টেশন হচ্ছে আমাদের কথা ও দুটো তিনটে আমার স্টেট দেওয়া আমি নিতে পারি अच्छा भी लगते हैं time for the appellant.
Malad, Mr. Nandi is appearing for the state. Malad, he has missed the
Brief. Mr. Nundi has missed the brief. I have nothing to say. I have nothing to say.
What is the conviction?
22? Nothing.
Next week we keep it.
Yes, Tuesday.
Paper books, what is the status of paper?
Like either that paper books have been made, but I saw 2 PB. No matter, please. Yes. In this case, well, we'll try
How many years you are in custody?
In custody since the conviction. I was 20 years on bail.
Paper books made.
Madam, please. Well, just listen to us, Malad. On Tuesday or Wednesday, because I gather Monday is a heavy bench. He told me Monday don't take anything. So, Malad, Tuesday or Wednesday,
Wednesday.
Wednesday? Wednesday. Okay.
The problem is, yesterday all matters have come over.
That's true.
Today again 3:30.
3:30. Malad, what resolution was to be at 1:30. I seriously oppose that we can't face the judges anymore. So until we get 3:30. But your lordship, what happened at 10:15 today, my lordship will know.
I'm telling you, what we said. After you...
No, yes, Marat. Your lordship...
And we did it, we discussed amongst ourselves and we decided we are not going to pass any order which will be prejudicing
to any of the parties. Any of the parties, sir.
There was one interim bill we confirmed. I think Ms. Maria was state. Others were where we found that bail is sought on delay. We pass the orders so that they come up 1 week or 2 weeks, and so the exercise of getting the reports
has to be
are done. So the people don't suffer again.
as a result for
day,
another day or
again another day. So
Yes.
these exercises we did, and we tried to spread out the matters also so that it doesn't burden us.
I know,
because it will.
I can't tell your lordship in the morning.
There was a
I had a fight today morning. I said, no way, how we are going to do it.
Mr. Mukherjee, please take that leadership. Some sensible approach has to be.
Yes, has to be. And then I put a proposal, my lord. If we take a 10:30, a Saturday, on that day itself, we fix up a Saturday. That is has to be done.
Lastly, we are in a committee discussing with the representatives of the bar, where the Law Commission proposal, Justice Lodha report of increasing the number of working days has to be looked into. Now, the proposal is for High Courts 222 days.
I mean, 12 days more.
12 days more. In fact, one of the representatives on the bar said, instead of disturbing the holidays, if we can have one working Saturday every month. That way, we don't disturb the holidays.
Because in Ranchi, what they do is, if they have that day, on that day itself, the date is fixed on a Saturday.
I suggested this with regard to one of the holidays which was shifted.
Yes, Malad.
Finally, didn't.
Stop in the Mr. Right of this.
No.
Oh, achha.
It was.
Nowadays, its militants have taken over.
They can't be over you.
No. I am a militant also then.
Listen, Mr. Mukherjee, militant or no militant, if you and Mr. Shekhar Basu agree to do something, I don't think anyone in the criminal bar is going to say it different.
We'll do that.
And we need to, because earlier I remember when I became a judge, and I strongly and very strongly contested. Some of my colleagues would always say,
you are the first.
No. That the stoppage of work is because of the aggressive attitude of the members of the criminal, which
that I can assure your lordship that will not.
I completely oppose that idea. I said it is not so. The members of the criminal bar, most of them are very young advocates whose appearance in bail matters are their livelihood.
Yes.
They never stop work. The stoppage of work are by overbriefed senior advocates, because they get the advantage of leisure and the pacing out of litigation. Because the litigation is never going to go away from them. They're too senior and well established for that. And it comes from bar associations like Bar Association number 2.
Yes.
All right.
Yes.
So,
Dr. Death.
We do not know. I don't want to name anyone or anything. It comes from those places. And they are camouflaged and packaged in the name and the excuse of rowdy juniors.
Yes.
I believe this, that even with all degree of rowdiness and lack of respect for seniority, the bar still now has a hierarchy where if the senior advocate says that please don't do this, 75 to 80% of the juniors are going to.
That's true. Today we saw it itself.
It will be done. It has to be done.
Right.
Because otherwise, it will be very difficult to. We will not be able to handle. You have seen what is the bad state of affairs in the magistrate courts today.
But my lord, circular direction is now taking shape.
Should.
Very good.
I am very happy people are abusing me.
Doesn't matter.
And I am happy because I realize that I have hit the nail. So it needs to be done. It needs to be done. And I tell you, Mr. Mukherjee, this is one of those changes which help and encourage working advocates, the advocates who work on their briefs. Because it does not, the delay is one of the armors in your repertoire.
Right.
You know, we cannot deny all this. The delay in a case is a very well-known defense tactics. People forget the passion with which someone approaches a prosecution goes with time. People become fatalistic.
Correct.
If you have a murder case trial within 1 year, I assure you conviction rate will go 5 times up.
That's
What happens is the eyewitness comes after 5 years. So many extraneous influences take place. So if you tighten the entire process, the collateral operators will suffer and the working brief advocate will gain ground. So that is another
That's
area
right,
which I want to.
because I'm waiting for the
And
new
the third
second
thing
to
I
come.
tell you, which will, I want to make it a threat to all the defense advocates, is to ramp up the legal services authorities so that they are a competitive player in the field. Today, who does not have money goes to legal aid. I want to create a legal aid where people line up to go to legal aid. That they have the best advocates, they are most efficient, and they are cheap and reasonable.
But one thing is there, Malak, Legal Service Authority, being a government arm. Malak, I got a brief
I know.
two years back. Nothing has happened after that.
I know this problem is, I'm telling you, because we have to change our secretaries in the legal service.
Yes.
There are a couple of people who know exactly how the lawyers operate. If we can keep them, the synergy is good. And
And the flow will be
what
better.
is necessary, Mr. Mukherjee? When you, Mr. Ganguly, are appointed, I have continuously said, ask them for a chamber junior who can be fixed with him.
Yes.
So that the way in which you work is known to your office juniors.
Yes, Malak. And it works.
Secondly, there should be a conference between you and the trial court lawyer, which in private defense,
Correct.
that is one of our main stays.
That has to happen.
What sort of defense you took, why you
asked this question?
otherwise there is, what is happening is, even in the Supreme Court we have seen Supreme Court appeal, the Supreme Court Legal Services Committee appoints, but what we have argued here is not really
Not
always
there, not
communicated. This communication is also necessary. Thank you, Mr. You are very efficient. Very अगर वो competitive हो गया ना, people will line up.
On treatment also.
Yes.
97.
Mr. Chattopadhyay. Elder brother came in morning with some newspaper. We said, first write a petition, then you come. 2 newspaper. Appeal. But not only that, let the pen drive come. And the proof of this, it threatened me.
সব একজন করে
It says that hooligans came and I get that factual foundation. I am jumping the gun. I am jumping the gun. That's why I said, get better please be good. That's why I know. I am investigation and extremely modern. But I think really approached. But then these are collateral.
My lord, this matter was heard last time and your lordship called
Your
for
lordship
report
called for on merits
to
or
down
the merit
from the correctional home.
from the correctional home.
Day one, my lord, you are, my lord,
Suffering from pancreatitis.
in the hospital. It appeared from the order
will.
sheet.
Appellant submits he is suffering from or you will go out, you will kill yourself. You will start drinking again. At least in jail, we don't live in utopia. You smuggle in alcohol, but less amount. Now, unhindered alcohol intake, you will die. You're suffering from pancreatitis because of
On the day one, 2020.
because of cirrhosis of liver, alcoholic cirrhosis. Appellant is suffering from acute pancreatitis. Absolutely. Acute pancreatitis. He is under medication. He had been under medication in Bardhaman Medical College and Hospital, full stop, in order to render better medical treatment. He prays for suspension of sentence. Learned lawyer for the state submit report. From the report, a report shows appellant is ill and is under regular medical treatment at the hospital and is under treatment in the hospital. Without going into the merits of the case, without going in and purely on humanitarian considerations, we suspend the sentence of the appellant and release him on bail. 10,000. इसके बाद डेथ सर्टिफिकेट 20.
May I please your lordship?
चलो वो 9 वाला 9 स्टेबलाइज हो गया.
That conviction under section 302, life is imprisonment, my lord. Petitioner appellant is in custody for 4 years. There was a dying declaration.
Dying declaration. Petitioner is in appellant is in custody for 4 years. He prays for suspension of sentence. Learned lawyer for the state opposes the bail prayer. We have considered the materials on record. Appellant is the husband.
No, appellant is the sister-in-law of the
Sister-in-law of the victim lady. Full stop. The victim made a dying victim recorded a dying statement in the hospital implicating the appellant. The statement was exhibited as Exhibit 17. In view of the aforesaid evidence on record, clinching evidence on record, and as the appellant is sentenced to life imprisonment, we are not inclined to suspend the sentence. Paper books ready? Paper books be prepared within 8 weeks, liberty to make. Next. Paper book ta hoyche kina dekhe nao. Ota debar age ota dekhe. Yes, Kushal.
99 on the earlier occasion that I had handed over the copy of the evidence. But kindly see the evidence.
Yes, Mr. Rai.
Well, they were all along on bail. The petitioner's daughter, appellant number 1's daughter died.
They foretold of the son-in-law. There was a village mob fury. He was lynched. There were about 600 people.
There is no specific identification. Appellants were on bail during trial and did not misuse his liberty. It is contended the prosecution witnesses did not disclose specific role of the appellant in the assault. Full stop. They were convicted on mere suspicion. They
were named, but
no specific effort. They pray for suspension of sentence. Learned public prosecutor opposes the bail prayer. We have considered the evidence on record. Victim was the son-in-law of appellant number 1. His appellant number's wife, daughter died under unnatural circumstances. This led to a mob fury and public lynching. Most of the witnesses, prosecution witnesses do not attribute specific role, any specific role of the appellant in the mob attack. Full stop. Appellants were trial judge ignored the omnibus statements of the witnesses and relied on motive to implicate the appellants in the murder. This, the manner of appreciation of evidence appears to be contrary to settled principles of law. Appellant has made out an arguable case in appeal. They were on bail during trial and did not misuse their liberty in any manner whatsoever. Under such circumstances, we are inclined to suspend. Yes.
Well, item number 100.
100.
My lord, Mr. Ahmed is appearing on behalf of the contempt. My lord.
Monthly list of March, not this one. What is that? Monthly list of March on the prayer of the party.
Hmm. 101.
So I am for the CPI, lordship. One for the petition.
This is for default. Mr. Omajit Dey for CPI. 102.
102.
Lord, in 102, my lord, I am appearing for the petition. My lord, my instruction is, my lord, to pray for withdrawal of the matter.
Not praise.
Lord,
How's your neck, Miss?
Little better.
Paria?
Very slightly I got saved. Otherwise,
Shell down.
I have a problem of vertigo. So one day, like one Saturday, the day of the cricket, I was getting myself ready. I fell down and the disc came out.
Not pressed.
Grateful, man.
will you lord keep this letter with the lordship's file? File. I'm great.
Yes.
Stockage, the directions to file a reply. 106. In the next week, Mr. Bhattacharya will appear.
What Mr. Bhattacharya?
Specifically requested.
Who?
Mr. Bhattacharya.
But I'm for the de facto complainant, my lord. A specific violation of my lord's order.
Absolutely wrong. Absolutely wrong.
Absolutely wrong.
Yes, my lord, I can show it to you. Kindly see the report filed by the state in the last document.
Tell us.
Here, they have mentioned that the Horishchandrapur police station submitted a
Read the report. That on 1810 there is
Order was passed on 12th October. Since 15th October, there has been violation.
My lord, may I show one thing?
Please read the report. All right, where is the GT? Where is the inquiry into this letter? Where is the inquiry into this letter? Do you know you have filed a report? What is the report?
I don't have the copy with
I don't want me.
I'm for the appellant, Lordship. Appellant state, Lordship. We have filed the application. Lordship, we have filed this cancellation petition for cancelling the bail of two accused persons, Chandan Jadhav and Anil Jadhav. And on the last occasion, we have filed the affidavit in reply, and your Lordship was pleased enough to direct the accused.
Mr. Shekhar Burman was appearing.
He was appearing. He was supposed to give reply to our
nobody appears for the opposite party number 1 and 2. Notice be issued upon learned counsel for opposite party number 1 and 2. Matter will appear 4 weeks hence. Intimating them of the next date or about the next.
Hi.
105.
On the last occasion, your lordship directed to form a medical board of the SSKM hospital to for conducting medical test of the and my lord, out of 5 medical tests, my lord, 3 has been done, but 2 medical tests. MRI
More than 6.
my lord, because the opinion of the medical board has not been
to submit report with regard to the health of the opposite party accused. Matter will appear 4 weeks hence. 4 weeks hence.
As per verbal instruction, they take some more time. They said that
opinion and not yet received. Opinion of medical
for the report. For the last 8 February, some examination is done.
Correct. When should we keep it? Tell us.
Extended time change. 5 weeks.
6 weeks. Next.
103 and 107.
This can be disposed of, my lord, because it reached the stage of 330. With the direction, my lord, that the thing should be concluded at the early date.
Then let us keep it after 3 months. In the meantime, let Mr. Ahmed contends that trial is at its fag end. In view of the aforesaid, let the matter appear in the monthly list of May 2024. Status of the proceeding be filed on the agenda. He also admits trial as opposite party accused has cooperated with the trial. Next.
108.
I'm for the opposite party number 2, Lordship. Lordship, this is the affidavit.
Examination going on.
Yes, Lordship.
What is the stage now?
Lordship, out of 14 witnesses, Lordship, 4 has already been examined, Lordship. The next date is on the 5th of March, Lordship.
All right.
Lordship, on the last occasion, they had filed a report, Lordship, and Lordship had given me the liberty to an opposition, Lordship. This is the opposition, Lordship.
After an opposition is placed on record, we are informed.
We have already served.
4 prosecution witnesses have been examined. Examination of further witnesses is fixed on 5th of March 2024. Opposite party accused is cooperating with the trial court and has not sought for adjournment during examination of witnesses. In view of the aforesaid, we adjourn the hearing of this application till we direct that the application shall appear in the monthly list of April 2024. Trial court shall proceed with the trial. In the meantime, parties shall cooperate with the trial court.
Lordship, the report of the
Report is kept on record.
Grateful, Lordship.
We want you to cooperate and
Lordship,
don't ask.
Lordship.
If you ask for adjournment delay, we are going to
Lordship,
cancel.
I have already conveyed that, Lordship.
Yes.
Grateful.
International.
Lordship, 109, I seek a 4 weeks adjourn. Cancellation.
On the prayer of CBI, adjourned for 6 weeks. We don't make any date in this. Under 10,
110.
urgent for the day. तो dismiss करते हैं, I'm not.
111.
I am for the private opposite party.
Mr. Rudra Nandi is appearing and praying for a day's adjournment.
Let us see the order sheet. Civil dispute, cancel bail and all. Next. Report with regard to progress in further investigation be positively filed on the adjourned date. A matter will appear 6 weeks hence.
Much obliged.
Opposite party shall cooperate with the investigating agency.
112.
Well, I am for the petitioner, my lord. I am filing reply, my lord.
Reply
against the opposition filed by the accused persons, my lord.
Same. What do you say? No, he is for the opposite party. You are for petitioner?
I am for the petition.
So what do you want? You want adjournment?
Yes, my lord, evidence in reply was filed.
All right. Affidavit reply is placed on record. On the prayer of learned counsel for opposite party, matter is adjourned 4 weeks. What is the stage of proceeding?
Stage of proceedings.
Commitment has taken place.
Just trial has not yet been started, my lord. Commitment.
Some of the accused still now abscond.
All right.
I have given, my lord, already given. এই যে বাবা already given, my lord.
Next.
113.
113.
I'm for the case for the petition. But this is my affidavit. Service.
Why bail should be cancelled? Why we should cancel bail?
But the petitioner is opposite party is continuously threatening my lord.
Go to the magistrate. Petitioner complains that opposite party has misused his liberty. Hence, he prays for cancellation of bail. We note bail was granted by the Chief Metropolitan Magistrate, Calcutta. Grievance with regard to misuse of liberty may be agitated before the said court. With this observation, application is disposed of.
114. How we can appear proceeding?
I am for this case.
I am for the petition, my lord. On the last occasion, my lord, it was directed by
Before magistrate.
Affidavits were to be exchanged, my lord. It has not preferred any affidavit.
You were accused.
No, my lord.
I am for the accused.
And my lord, on the other hand, my lord said to return 50,000 rupees which he took from my father.
Who took from your father?
My lord,
What did you do?
There has been an arrangement for marriage, and then more has been given for 50,000. My lord, I have talked to my client. My lord, if your lordship is direct, my lord, they will pay me, lord.
We cannot direct this as a condition.
My lord, otherwise, my lord, how can this amount be paid, my lord, before the court below, my lord?
No, not paid. You settle the matter. Let the matter be dropped.
My lord, we are concerned about the making of payment, my lord. My lord, where should I pay, my lord? That is the point. That is the difficulty, my lord.
I'll give you a receipt.
He will give a reason. You file an affidavit giving an offer that you want to deposit this.
My lord, kindly adjourn for fortnight, my lord, so that by this time, my lord, we can arrange all this.
Get adjourn for 4 weeks. Isn't it?
115.
You want cancellation?
307, my lord.
All your bail will be cancelled now. All bail you obtain for accused, we will now cancel. Huh? Opposite party?
We have served the copy upon the opposite party number 1.
Nobody is coming.
Not appear.
Give notice, huh? Officer in charge shall notify opposite party number 2 with regard to pendency of proceeding and next date of hearing. Matter will appear 4 weeks hence.
It's the first time I've been coming with this application.
The petitioner, my lord. This is the cancellation of bail, my lord. My lord, section is that, my lord, 420, 467, 468, 471, 476, 511 and 123, my lord. The order is, my lord, the 59, page 59, my lord. My lord. On the basis of that previously some cases are pending in between the parties, my lord, the bail has been granted, my lord.
What is wrong in it? We find no reason to interfere with this order.
My lord, they have not considered anything, my lord. Court below does not consider anything whichever in the complaint, my lord. My lord. And my lord, kindly consider, my lord,
the counsel contents that the gravity, that the accusations in the
my lord, actually, my lord, there was GST fraud,
were not
allegation of
considered
GST fraud, my lord.
by the learned magistrate while granting bail. He had merely referred to other pending proceedings by and between the parties. Be that as it may, we note that the order impugned is an interim one. Bail has not been confirmed. Under such circumstances,